We are not going to exec anything today, and this bill is going to subcommittee. The Rules Subcommittee will be working on Section 7, and tomorrow, we're meeting tomorrow at 10. Pensions Committee is going to work on Section 5, and they're meeting tomorrow at 1. And the rest of it is going to go, it's the Representative Roy's committee is going to meet tomorrow afternoon. And the rest of the bill will be covered by Michael Yakubovich's subcommittee, and they will be meeting next Thursday. Don't know which subcommittee you're on? I'll send you a note.
When will that be?
Which part?
You said you'll send us a notice, and when will that be done?
Actually, Miriam has already sent out the calendar notices for all 3 of the meetings, which lists the subcommittee members. So you can just look at
That works fine. Thank you very much, Madam Chair.
okay. And actually, Representative Schmidt, you're with Representative Pearson, and you're meeting on the 7th on Senate Bill 58.
Thank you as well.
So we will not be, as I said, execing anything today. We will be doing this section by section so that we can remember what the sponsor has to say while we listen to anyone else who's interested. And then we will.
No, that's great. That's a very good procedure. Thank you.
Most of these sections have nothing whatsoever to do with each other. So it's.
Right. Yeah, I noticed that. Yeah.
It's now 10 o'clock. I will open the hearing on Senate Bill 133, and I will read our script. Okay. As chair of the House ED&A Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee and scheduled in the House calendar for today. An executive session may be held on any bill referred to the committee. Please note there's no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen and, if invited, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. All votes that are taken during this meeting shall be done by roll call vote. We'll start the meeting by taking a roll call attendance. When each member states they're present, please also state whether there's anyone in the room with you during this meeting, which is required under the right to know law. Senator Sytek?
Okay. Representative Allegro,
Here in the room.
Representative Bailey,
Here in the room.
Representative Fellows,
Home alone.
Representative Flintno, Representative Flintno. Not yet. Representative Goley,
Here at home, and my wife is in the other room.
Representative Groda,
Here in my home office alone.
Representative Judy, No está. No, Representative Lanzara,
Mobile in Nashua, and I am alone.
Representative Lekis.
He stepped out.
He stepped out, but he is here in the room. Representative O'Brien. Representative Pearson. Representative Roy. Representative Santo Nestasto.
Home alone here.
Representative Schmidt.
I'm at my home office in Dover and I'm alone.
Representative Schuett is
I'm at my home in Pembroke alone.
Representative Schultz.
Good morning. I'm in Concord at my home, and my husband, Gene Taylor, will be in and out of the room.
The clerk is here in the room. Representative Yakubovich.
Home alone in the room.
Let me run through and see whether Representative Fontenot is here. Representative Judy. Representative Lekis is, we understand, sorry. Representative O'Brien.
He's there.
Representative O'Brien's here and I'm a home alone in Nashua.
Okay.
Thank you.
Representative Pearson. Representative, okay. We have 3 absences at the moment.
Thank you. All right. In that case, I'm opening the hearing and I call Senator Carson.
Good morning, Madam Chair. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have this morning for your consideration Senate Bill 133, which seeks to adopt omnibus legislation relative to occupational licensure. Madam Chair, there are 13 sections of this bill, and I will introduce each section. And I will,
Senator,
I'm sorry?
Senator, we're going to go section by section. So if you would just introduce section 1, for which you are the prime sponsor, and then we'll, and any other points you wish to make, but not specifically introducing each section.
Okay, thank you. Thank you very much for that clarification, Madam Chair. Section 1 deals with licensing places of assembly. This is a refile of Senate Bill 432, which was filed in 2020, which passed the Senate, but died on the table in the House during the COVID-19 pandemic. What this bill essentially does is it allows the Fire Marshal Office to issue a license for a place of assembly in situations where there is not a local authority to do so, or when they may ask the Fire Marshal's Office to provide a license. Thank you very much, Madam Chair.
Thank you. Are there any questions for the senator? Right, seeing none. I believe Paul Parisi wishes to speak on this section. Raise your hand, sir. There he is. All right. Okay, thank you. Mr. Parisi, when you're with us, please unmute and give us your wisdom.
Good morning, Madam Chair. Can you hear me?
Yes.
Good morning, Madam Chair, members of the committee. For the record, my name is Paul Parisi. It's my privilege to serve as the State Fire Marshal. I'm here today in support of Senate Bill 133, Section 1, which, as Senator Carson stated, it does allow us to issue, us meaning State Fire Marshal's Office, to issue a place of assembly licenses in the event that it's necessary to do so. Typically, place of assembly licenses are issued by the local authority having jurisdiction. For your edification, places of assembly are rooms or spaces where more than 100 people congregate, or 50 or more if it's a tent. Currently, when the authority having jurisdiction when there is no authority having jurisdiction, such as places like Greens Grant or the summit of Mount Washington or Dixville Notch, and there is no Board of Selectmen available to issue a place of assembly, there needs to be somebody to be able to do that. And currently no one can. So we filed this legislation in the hopes that at least the state fire marshal's office would be able to do so. And then also in consultation with us in the event that there is a local authority having jurisdiction, there are times when it's more prudent for us to issue it than them. So that's the purpose of the legislation. I thank Senator Carson for introducing it, and thank you for allowing me to testify.
Thank you. I believe Representative Broda has a question.
Thank you. Fire Marshal Parisi, how is this enforced?
Thank you for the question, Representative. It's typically enforced by the local authority having jurisdiction. It is part of the state law. So the local authority having jurisdiction would make sure that it's enforced. And in the event that there is no local authority having jurisdiction, then we would. But this would clean it up so that not only could we enforce it, but we could also issue the permit.
Thank you.
You're welcome.
Are there other questions from the committee? Seeing none, is there anyone else that wishes to testify on section 1? If you do, please raise your hand and we'll listen. Okay, seeing none, close the testimony from section 1 and move on to section 2. I will call Senator Rosenwald, who is the prime sponsor of section 2, and remind Representative Goley, O'Brien, and Pearson that they are our co-sponsors and will not be asking questions.
Thank you. Good morning, Madam Chair and members of the EDNA Committee. For the record, I'm State Senator Cindy Rosenwald from District 13 in Nashua, and I'm happy to be here this morning to introduce part 2 of this bill, which repeals the Emergency Medical Services Personnel Licensure Interstate Compact, known as REPLICA. This was enacted several years ago in New Hampshire, but has never been used. And in fact, the nearest state that has adopted the compact is at least 500 miles away. The compact would not enhance public safety because here in New Hampshire, we already conform to licensing and certification regulations from other distant states. This action was included in Senate Bill 540 of last year. It, at the time, passed the Senate on a voice vote, and then we included it in an omnibus bill that unfortunately was vetoed for other reasons. I hope this committee will recommend it ought to pass as an idea that we tried, but we weren't able to be successful. Thank you, Madam Chair.
Okay, thank you. Are there questions for the senator? Representative Roy?
Thank you, Madam Chair. Thank you, Senator, for taking my question. You said that we enacted this several years ago, but isn't it true that it was just last year during the middle of the pandemic that it actually got going because of the necessary committee staffing, et cetera?
I'm sorry, I wasn't able to hear the part of your question after, but wasn't it also true?
Isn't it also true that you said the committee or that this was enacted several years ago, but isn't it true that it really wasn't operating until last year during the middle of the pandemic due to it had to be staffed, et cetera?
I'm not aware of the staffing. Thank you for the question. But my understanding is that it requires a number of states to enact it before it can become enforced. I believe there are other people who can testify to the details of it.
Okay, I'll save that.
Thank you.
Thank you. Other questions for the senator? Okay, seeing none, thank you.
Thank you, Madam Chair.
Christopher Arnold.
Good morning, Madam Chair and honorable committee members. The Department of Defense appreciates the opportunity to opine on the policy changes reflected in Part 2 of Senate Bill 133. My name is Christopher Arnold. I am the Northeast Region Liaison at the Department of Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. First, we would like to discuss Part 2 of this bill, which the department has deemed to negatively impact our licensure efforts for military service members and their spouses. To date, 22 states have adopted replica legislation, making the over 5,600 licensed EMS workers in New Hampshire eligible to practice in these states, including many who are military spouses presently residing in other states that would lose their eligibility to continue working were this bill to pass. In 2018, the Secretaries of the Army, Navy, and Air Force issued a policy memoranda to the National Governors Association, noting they will, quote, consider the quality of schools near bases and whether reciprocity of professional licenses is available for military families when evaluating future basing or mission alternatives. These considerations were codified by Congress in the 2020 NDAA, which requires the department to produce annual scorecards at the installation level, considering military family readiness issues, including interstate portability of licensure credentials. In a prior scorecard in 2019, the Department of the Air Force's Strategic Basing Office evaluated New Hampshire as green for EMS licensure following the 2018 passage of replica. The Air Force's approved criteria gauges states' policies for accepting professional licenses for EMS as part of its strategic basing process. Future Air Force basing decisions made with a consistent framework will ensure optimal conditions for service members and their families. This evaluation was mirrored by DoD's assessment in the 2020 letter to Governor Sununu, accompanying the SecDef's report on spouse licensure, which assessed the Granite State as green for licensing compacts. The department perceives that Part 2 of Senate Bill 133, which proposes to repeal the EMS compact, negatively impacts military spouse licensure. New Hampshire already limited the scope and implementation of replica in its original statutory framework, which prohibits a replica provider from picking up regularly scheduled shifts. If passed, Part 2 of Senate Bill 133 would make New Hampshire the first state to ever leave a licensing compact, which would undermine our efforts to create license reciprocity for service members and spouses nationwide, opening the door to other states repealing compacts under a misapprehension that New Hampshire had left a compact for a legitimate purpose or following serious study. It has been established that New Hampshire is having difficulty recruiting and retaining licensed EMS providers. In addition to the benefits to military spouses, the EMS compact addresses this issue by making the state more attractive to out-of-state EMS personnel, as well as making it easier for New Hampshire residents to practice out of state. And of course, our military families are well served by having the means to move expeditiously from state to state. A 2018 study by the Federal Trade Commission recognized there are two approaches to alleviating barriers to license portability, namely mutual recognition, which relates to occupational licensing compacts, and expedited licensure. Occupational licensure compacts provide consistent rules for licensed members to work in other states. Simply put, the EMS compact facilitates the day-to-day movement of EMS personnel across state boundaries in the performance of their duties as assigned by an appropriate authority without jeopardizing public safety. Common misinformation about compacts is that they either lower or raise the standards for the occupation, when in fact, compact states have the option to issue a compact license and also a state-only license to maintain their state standards. Amongst the provisions, compact states utilize the National Registry of EMTs examination as a condition of issuing initial licenses at the EMT and paramedic levels, the same standard for a military combat medic and highest in the world. The NREMT standard required by replica is in fact the competency standard upon which New Hampshire's certification requirements are based. Compact states require EMS personnel to complete an FBI biometric criminal background check when applying for a new EMS license, share licensure data, including licensed disciplinary actions with other compact states, and have a mechanism in place for receiving and investigating complaints about individuals, which does not exist for non-compact states. EMS personnel need to be licensed in good standing in a home state and practice under the supervision of a physician. Qualified EMS personnel in compact states are extended a privilege to practice in other compact states on a short-term intermittent basis. The EMS compact is governed by commissioners appointed to the Interstate Commission for EMS Personnel Practice by member states. Each state has 1 seat on the commission and 1 vote on each matter brought before the body. The best evidence we have about the quality benefits of licensure involves occupations that have more harmonized standards across states. Thus, there are very clear quality benefits to healthcare licensure regimes governed by interstate compacts. The department does not have any strong evidence to suggest that the type of license recognition and replica is associated with worse quality or worse care outcomes. As the Obama administration 2015 report from the Council of Economic Advisors observed, quote, well-designed licensure can enhance safety when consumers or patients would find it difficult to personally assess the quality of services they receive. But this does not provide a justification for any conceivable licensing restriction. Excessive or poorly designed restrictions can generate a number of costs. Excessive restrictions can even impair public safety when they reduce access to high-quality licensed services. That is why, to support our military, the department recommends stripping Part 2 out of this bill. Conversely, we strongly support and urge passage of Part 5 of the bill to enact the Audiology and Speech-Language Pathology Interstate Compact and the Occupational Therapy Interstate Compact. The department remains committed to improving license portability for military spouses. The Secretary of Defense has established military spouse employment as a key aspect of supporting military families, and the secretaries of the military departments have also expressed the importance of military spouse licensure by making it part of the consideration for future mission basing. The department recognizes the great work that has already been done by your state to support military families. We hope you continue that effort today. I stand ready to answer whatever questions you may have. Thank you.
Thank you. Representative Schmidt, you have a question?
I do, Madam Chair. Thank you very much. Mr. Arnold, thank you very much for your testimony. You may be aware that past iterations of this committee have worked very carefully to try to remove the kinds of obstructions that you're referenced in your testimony. I'm wondering, my first question is whether you or anyone from your office offered this testimony before the Senate in its negotiations and dealing with this bill.
Thank you, Representative Schmidt. Yes, we did testify at the Senate hearing and submitted testimony to the Executive Departments and Administration Committee, as well as the Senate Finance Committee. Understanding that military spouses need assistance now, the department advocates that states should pursue multiple approaches to reciprocity simultaneously, including near-term actions to attain a baseline of getting military spouses a license within 30 days based on minimal documentation, which are among the efforts that you referenced that have been previously undertaken by this committee, as well as long-term solutions for reciprocity through licensing compacts. And indeed, New Hampshire is a member of 4 interstate licensing compacts, including replica, and should Part 5 of this bill pass, will be a member of 6 interstate licensing compacts, becoming one of only 8 states to have joined the 6 major health licensing compact frameworks. So we absolutely salute all of your past efforts to support our service members and their families.
Follow up, Madam Chair.
Follow up.
Thank you. And will you or someone from your office be available? I believe we're going to have subcommittees to deal with some of these issues. Would you or someone from your office be available to assist us in that effort?
Roger, we would be happy to do so.
Thank you. Thank you, Madam Chair.
Representative Baroda?
Thank you. So in your own words, can you estimate the number of people or a number of service people this bill would, removing this would affect? What would be the impact in New Hampshire on this?
Roger, so there are 2 elements that we're talking about. One would be, persons operating in New Hampshire under a compact license. And as was mentioned earlier, the compact was passed in 2018. And there are steps that are taken in order to become a full-fledged member of the compact, which I believe was completed last year. So there's only one person operating under a compact license right now in the state of New Hampshire. However, there are individuals who are domiciled in New Hampshire and involuntarily reside in other states as a result of being military spouses. And in those compact states, those individuals could stand to lose their eligibility to continue working were this compact to be repealed.
Follow up, and how many people are in that category?
So the what's known as the Defense Manpower Data Center does not track personnel in that fashion. So it is a difficult question to answer, but of the 5,600 licensed EMS workers in New Hampshire, at least some of them are military spouses.
So we don't have that information.
Negative. And there is a national EMS coordinated database that is maintained by the compact. So I'm sure when the folks from the compact testify, they can answer more specifically as to how many persons practice under compact licenses on a given day. But in terms of tracking, home state licensure out of state, that's not the level of the Department of Defense's involvement.
No. Thank you.
Thank you.
Are there other questions? Representative Roy?
Thank you, Madam Chair. Thank you for taking my question. With regard to this bill has several aspects. It's got the DoD one and then just other people who wish to use compact licensure. With regard to the DoD portion of it, we're talking about how many New Hampshire people are using it in other states and how many people from other states are using it in New Hampshire. But let's talk about bases. So if the DoD is grading bases on its friendliness, for lack of a better term, to military spouses and their ability to gain employment in the state, and all things being equal, say between Burlington and Pease Air Force Base, and base closures are discussed as part of that grading system, would this potentially be a reason that a decision against Pease might be made?
Roger, Representative, thank you for the question. I would refer everyone to the Air Force's strategic basing evaluation, which is available on the Department of the Air Force website. And as I indicated in my testimony, the 2020 NDAA codified what was already a voluntary practice by the Department of the Air Force to release these annual basing scorecards. In their methodology, the Air Force evaluates 9 occupations: accounting, cosmetology, EMS, engineering, law, nursing, physical therapy, psychology, teaching, and other professions, in as much as those are the professions that have been identified where the most military spouses are practicing. So to the extent that in their 2019 evaluation, Pease Air National Guard Base was green for EMS, that rating would be negatively impacted by the passage of Part 2 of Senate Bill 133.
And I'm not sure if you're aware or able to comment on this. Do you have any idea of the economic impact to the state and the area in general if Pease were to close?
Sorry about that. I had to unmute myself there. So in terms of base realignment and closure, that's a 4-letter word, if you will. And I can't speculate on what the impact of that might be. But according to the Office of Local Defense Community Cooperation, which evaluates defense spending on an annual basis, the economic value of Pease is approximately $3.1 billion, which is 3.5% of the state's gross domestic product, and ranks 14th overall in the United States. And it supports a total of 6,337 personnel. And all states are bound by all services are bound by the requirement in the 2020 NDAA to release the basing scorecard. So it would also apply to the cold lab up north in addition to the airbase.
Thank you.
Are there other questions? Representative Schmidt, do you have another brief question?
Yes, I do, Madam Chair. Thank you. So Administrator Arnold, is there technically the Portsmouth Naval Shipyard is considered by this as part of the state of Maine, but it impacts this state as well. Has your office studied any impact with regard to Portsmouth Naval Shipyard?
Roger. So there was a bit of a Zoom underwater there, Representative Schmidt. My apologies, but I did hear reference to the Navy Yard. In as much as we're talking about the annual basing evaluation, we do also have, an evaluation for the state of Maine, which is also in my region, and it is considered, part of the city of Kittery, if you will. But I believe, in as much as there are personnel likely living in Stratford or Rockingham, we look at both states holistically to support the service members who are assigned there.
Thank you.
Other questions? I call Brian Rill.
Good morning, Madam Chair and members of the committee. My name is Brian Rill, and I serve as the president of the Professional Firefighters of New Hampshire, representing 2,000 active and retired firefighters and paramedics throughout the Granite State. Today, I'm providing testimony in support of Senate Bill 133, Part 2, repealing the Emergency Medical Services Personnel Licensure Interstate Compact, otherwise known as REPLICA. Senate Bill 133 in its entirety provides a number of occupational licensure bills that would potentially improve the delivery of services to the New Hampshire taxpayer. While we see the benefit in many of these licensure compacts, not all licensure compacts are created equal. Part 2 of this bill will actually repeal a compact agreement that can be detrimental here in New Hampshire. The Emergency Medical Services Personnel Licensure Interstate Compact that is currently in place creates confusion in our current EMS system, lowering the quality of care delivered, and has the potential to weaken our state's economy. The current model allows out-of-state EMS personnel to migrate into New Hampshire on a routine basis to provide medical care and to transport patients to out-of-state hospitals, drawing New Hampshire expanded Medicaid dollars out of state. Currently, there are no bordering states that participate in this compact, which means that these services would be migrating in from well out of state, working in New Hampshire intermittently, not paying property taxes, and creating a loss of revenue. Furthermore, the replica model allows for circumvention of the emergency response models and mutual aid agreements that have been proven to be successful throughout our state. Municipalities must continue to have the autonomy to oversee their individual public safety response based on their community's needs. Should the replica model be utilized, it would create unnecessary confusion within our EMS system that could have a negative impact for the municipality, the provider. You may hear testimony today that replica is a valuable tool that can provide assistance in New Hampshire during a disaster or a pandemic, when in fact the governor already has the ability to access this assistance under the Emergency Management Assistance Compact at the federal level. You may also hear that replica is law in 21 other states. All of these states are located in the southern and midwestern areas of our country, where the EMS systems are rural and mutual aid agreements are far less robust than EMS systems in New England. Currently, we are navigating the worst unplanned emergency and global pandemic that we've ever seen without needing to utilize replica, proving that this is a model that we simply do not need in our state. Instead, we must continue to rely on best practices and proven methods that are effective here in New Hampshire to deliver the best possible quality of emergency medical services to our citizens. This bill passed the Senate last year, and unfortunately it was vetoed in an omnibus bill at the end of the year. We were pleased to see this bill pass the Senate once again this year with overwhelming support, and we respectfully ask this committee to do the same by passing SB 133 Part 2. I've submitted written testimony, and I'm happy to answer any questions that the committee may have. Thank you for your time.
Thank you, Mr. Rill. Are there any questions? Representative Roy.
Thank you, Madam Chair. Thank you for taking my question. Could you put a little meat on the bones for me when you talk about other states, people coming in, taking away mutual aid or taking people to hospitals out of state? If no bordering state is a part of this compact, can you explain how that would be possible?
Yes, Representative, thank you for your question. So currently we have mutual aid agreements that are designed specifically based on the communities in need and what their needs are. And these are typically put in place by department heads for EMS agencies and fire departments alike. What this does is it evaluates what the community's needs are and how to bring in those resources when our current resources are overtaxed. With no bordering state that participates in this compact, what that means is services could bring in out-of-state individuals or personnel from, let's say, Alabama or Kansas or Texas or one of the other participating states to come in and work in New Hampshire as a licensed EMS professional. The gentleman that testified before me, well, he spoke to everyone having a national registry of emergency medical technicians license. What they do not have is a New Hampshire provider's license. And so they are operating under their home state's medical direction and their home state's scope of practice. And in here in New Hampshire, we have a medical control board that establishes best practices for EMS within our state. And when you bring in this personnel from out in the Midwest or from southern states that have no idea of how we operate our EMS system here in New Hampshire, the waters get muddied and there's no clarification on what the appropriate standard of care is here in New Hampshire.
Follow-up.
Thank you for, I'm not sure that addressed the question as far as coming in from out of state and taking patients away, but let me ask this. Isn't it true that under the compact rules that if someone from another state is here practicing on their license from another state, they have to comport with New Hampshire rules under the practice? Isn't that part of it? That whatever state you're in, those are the rules that apply, not the state you came from?
So I don't believe that's the case, Representative. The way I understand it is the National Registry of Emergency Medical Technicians establishes what the guidelines are to practice within other participating states, and a member operates under their home licensure.
Thank you. Representative Schmidt.
Thank you, Madam Chair. Mr. Rill, how realistic is it that someone would be brought in from Texas or the Midwest? The Midwest is 1,000 miles away. Texas is even further away. So what's the reality in a situation that you're detailing here?
What the reality is, Representative, thank you for your question. To be honest with you, I do not know. But anecdotally speaking, I can tell you that this has been marketed as a product that essentially will help in an unplanned emergency or a state of emergency or a global pandemic. And it's something that we've not utilized. It's something that's on the books. And again, anecdotally speaking, you could have services that bring in out-of-state personnel to come into state for an undetermined amount of time to help with their workforce, and that money does not stay in state. They're here for a short amount of time, and then they turn around and they go home. So again, anecdotally speaking, it certainly could happen. I don't know that it's happened yet because, again, this is a law that's on the books that we just don't use.
Follow up, Madam Chair. So if the we're going to have to resolve this, and the subcommittee will be working on it. Will you be available to us or someone from your office to help us deal with this situation?
Absolutely, sir. I can send you all my contact information. You can contact me at any time.
Thank you.
Other questions? Representative Bailey.
Thank you, Madam Chair. You've several times referred to an unplanned emergency, which puzzles me somewhat. Could you give me an example of a planned emergency?
Thank you for your question, Representative. To be truthful, that was a direct quote that I took from testimony in opposition to this bill from the Senate hearings. So that was in the actual notes from that hearing. So while that's one of the terms that is being used to oppose this bill, I agree with you. I don't necessarily know what that means.
Thank you.
Thank you. Other questions? Thank you, Mr. Rill.
Thank you.
Mr. Romanello?
Good morning. Can you hear
Yes, we hear you.
me, ma'am?
No, you're breaking up, sorry.
Thank you, ma'am. So thank you, Madam Chair.
That's better.
Sorry about that. So thank you for your time and allowing me a few moments to speak. As far as the EMS personal licensure interstate compact, removing that tool from New Hampshire has yet, from a tool that New Hampshire has yet to benefit from, would be a drastic measure. The compact was declared fully operational in March of 2020 in response to the COVID-19 pandemic. At this time, there are 21 states participating in the compact, which is an increase of 6 additional states since New Hampshire adopted it in July of 2018. To date, this compact has not been used within borders of New Hampshire and thus has produced no instances where it has been proven to show no benefit to grant staters. On the contrary, we have seen the compact used by New Hampshire EMS providers in other states. Most recently, a fellow compact state, Colorado, called for national assistance in battling wildfires within its borders. The state of New Hampshire wildland firefighting team responded to this cry for help. As part of this team, a local fire chief was able to provide care for her teammates as well as residents of Colorado, utilizing her privilege to practice care with no delay, all because of the EMS compact. If New Hampshire was not participating in the compact, Chief Lund would have not been able to provide care without delays of obtaining an emergency licensure, which could have put her team at risk if injury occurred. Although New Hampshire has not directly benefited from the compact, to repeal it and subsequently take this tool out of the EMS's toolbox is a step backwards. This compact extends a privilege to practice to EMS providers only and does not bypass the requirements of departments and agencies wishing to provide EMS services in our state from being licensed as an EMS unit by the Bureau of EMS. This compact simply allows a mechanism for our appropriately licensed units to have access to additional workforce if ever needed. Furthermore, within the originally adopted language, safeguards were placed disallowing the use of providers under this privilege of practice extended by the compact as regular and usual staff personnel. In the RSA 153A20 section 24 spells this out. In closing, the compact does no harm to the residents or visitors of the state of New Hampshire. The compact enables our 5,600 licensed EMS providers to be part of a 21-state initiative that extends a resource to one another. This comes at a time where there is a national recruitment and retention problem to public safety, as well as what we hope to be the curtails of the largest pandemic in history. In regards to some of the other questions that were asked, I want to make it clear that EMS services in the state of New Hampshire are only to be provided by licensed EMS units. And how those licensed EMS units provide that care is through licensed EMS providers. So any use of the compact and access to additional providers would still have to be done through a licensed EMS service. So we're increasing a workforce, but we're not bypassing who is a. I'm happy to answer any questions, and I'm also available for the sub.
Thank you. Mr. Romanello, would you please, before you answer questions, introduce yourself and explain who you are representing and if you'll support our subcommittee?
Certainly, ma'am, and I apologize for that. So my name is Justin Romanello. I'm currently the chief of the Bureau of EMS for the state of New Hampshire. And again, I'm certainly available tomorrow to answer any questions or assist in this effort.
Thank you. Are there any other questions for Mr. Romanello? Seeing none, thank you very much. Mr. Warren Perry.
Thank you, Madam Chair. For the record, my name is Warren Perry. I'm alone in my office in Concord. I am the Deputy Adjutant General for New Hampshire's Department of Military Affairs and Veteran Services. I appreciate the opportunity to testify today, and I want to echo the comments of Mr. Chris Arnold with regard to our opposition to the repeal of the Replica Act. In principle, the purpose, or in part the purpose of entering into this compact was to assist in the portability of licensure for military members, members of the National Guard and Reserve, and their spouses as they complete active duty tours, or they are ordered to New Hampshire or out of New Hampshire on military orders. Repealing this act or this compact would adversely impact that population. So on that note alone, the department opposes this proposed repeal. We would urge the committee to consider very favorably amending Senate Bill 133 to eliminate this Part 2. I won't repeat any of the comments we've heard in opposition to this bill already, but I'm happy to answer any questions, and I'm happy to participate in the subcommittee if necessary. Thank you.
Thank you. Representative Schmidt.
Thank you, Madam Chair. Mr. Perry, it has not yet been alluded to directly, but telemedicine is an ever-expanding phenomenon, and an aspect of modern health services. To what degree would that be impacted by this part of the bill?
I'm not an expert in emergency medical technicians or telemedicine. I would make this assumption that it would not, telemedicine would not impact this very much, right? Because EMTs are generally first responders who are generally on the scene for incidents. So, you know, if I make the assumption that EMTs are responding to incidents, then they have to do that in person, that telemedicine would not be impacted.
Thank you.
Are there any other questions? Seeing none, is there anyone else who wishes to testify on Part 2? There are a couple of people. Chris Starwes. Oh, actually, he's Eric Shellberg and Clay Odell. So,
Thank you, Madam Chairman. Can you hear me?
yes,
Very good. Thank you for your time, and members of the committee. I'd like to thank you for the opportunity to speak on this. My name is Eric Shellberg. I am the president of the New Hampshire Paramedic Association, and today we are requesting the committee to strike out removal of Part 2 of the Replica Compact. A lot of what you have heard today, I will not rehash on. Those were points that I was going to bring up. That I would just like to touch on that I have submitted written testimony on behalf, and I hope that your group has received that. That the EMS Compact is, as Chief Romanello stated, is a tool for New Hampshire to utilize in the event of what was earlier called an unplanned emergency. I would consider to be a natural disaster or crisis that are above and beyond what would normally or typically be seen. This is a mutual aid tool that can be utilized to bring in personnel to assist with the delivery of pre-hospital health care in the state of New Hampshire. All compact members required to be certified to the National Registry of EMT level. Therefore, there is a base level of training and understanding of pre-hospital medicine. There are nuances with New Hampshire's protocols. However, there is a great level and standard between all levels within the National Registry. That being said, this is a tool that can be utilized as necessary. Specifically, there is no freelancing allowed, so individuals could not just come in on day-to-day operations or be utilized or be used to fill scheduling shortfalls. This would only be used in times of crisis or mutual aid. This can generate a force multiplication and will allow for greater protection and service to individuals in New Hampshire, citizens of New Hampshire in times of emergency. I also do stand ready to answer any questions you may have and also to assist in the subcommittee if necessary. Thank you.
Thank you. Representative Schuett, you have a question?
Yes, I did. Thank you, Madam Chair. Mr. Schelberg, did the current, well, I don't know if they're still current, but the emergency orders that were put out for the current pandemic allow such interstate mutual aid, as you termed it?
I am unable to answer that question for you, ma'am. That question may be better suited to Chief Romanello, as I'm not familiar with the emergency order specifically, that if there was an emergency order that requested out-of-state assistance.
Thank you.
Mr. Romanello, can you answer that question? While he's coming back on, Representative Rhoda, you have a question?
Thank you. I have a question for Mr. Romanello. Could you clarify if you are a member at large on the board of Replica?
So I'm back on. This is Chief Romanello. I got half of that question, ma'am, only because I was coming back on to speak.
Okay. Do you want to answer? Okay, my question is: are you an at-large member of the board of Replica?
So to answer your question, that is correct, ma'am. So as the state director for New Hampshire and representing New Hampshire on the Replica council, I also was asked to be represent the commission itself as a member of the board of directors, as a member at large. Correct.
Thank you.
And I believe the other question that was asked was, do our current emergency protocols allow for mutual aid? I believe that's what was asked. I apologize.
Whether an emergency order called for mutual aid through the compact.
So it did not. We didn't see a need. We were certainly thinking about the need if it did arise, and we could ask for assistance. But again, because the closest border state or closest state where we would get resources from would be Delaware, it certainly would prove difficult. Now that doesn't mean other states couldn't have assisted, but again, the EMAC request that the governor can ask for through Homeland Security would certainly satisfy that. And we also would have to pay respect to the additional language in the rulemaking section of the law that we couldn't use it for day-to-day staff. And so we would have to skirt around that if we were going to attempt to need to increase workforce in this pandemic, or hopefully it doesn't happen again, but if something were to happen in the future.
Thank you. Are there other questions for Mr. Schelberg or Director Romanello? In that case, Mr. Stowaz.
Good morning. Thank you for the opportunity to speak with you today. My name is Chris Stawaz, and I'm a lifelong New Hampshire resident. I currently reside in Hollis, and I'm the Regional Director of American Medical Response, New Hampshire's largest 911 provider. I've been a nationally registered paramedic for the last 35 years. Full disclosure, I think I'm the author of the unplanned national emergency verbiage. I believe that was in my testimony last time. Didn't think it would cause a ruckus, but I did say unplanned. I oppose Section 2, the repeal of the Emergency Medical Services Licensure Compact. New Hampshire New Hampshire's participation in the EMS Compact solved the potential problem. It created a specific and defined process for licensed qualified EMS staff to safely cross state borders when needed in the performance of their duties without having to hold multiple state licenses. New Hampshire actually participates in approximately 43 interstate compacts, and Replica is similar in language and intent to all of the other licensure compacts that New Hampshire has chosen to participate in. When New Hampshire became the 15th state to join Replica in 2018, it was the result of a collaborative effort of numerous New Hampshire EMS stakeholders, including the fire service, commercial ambulance providers, New Hampshire hospitals, and many of the volunteer EMS community members we're so lucky to have in our state. Now that the Replica Compact is fully operational, there are currently 21 member states, and another state will join on July 1st, bringing that number to 22. A couple of quick facts about Replica, what it does or does not do. It does not provide anyone with a multi-state license. It does not create automatic license reciprocity. It does not pertain to ambulances, only licensed personnel. It does not have authority over EMS or ambulance agency licensure, and it does not supersede the state of New Hampshire EMS laws or rules. It certainly does not allow for self-deployment, and it does not allow for routine day-to-day operations or response. It extends a privilege to individual providers to practice in member states under authorized circumstances and only to qualified, vetted, licensed providers for specific purposes. New Hampshire has actually used this compact, as Chief Romanella mentioned, when deploying local firefighters to wildfires in Colorado. It also stands up a national coordinated personnel database, which allows the New Hampshire Bureau of EMS to view complete multi-state license history of individuals, share real-time significant investigatory information, share license discipline history, and receive cross-border notifications of out-of-state adverse reactions. Notably, as Mr. Arnold and the other gentleman from the DoD mentioned, it creates an expedited licensing process for the members of the military and their spouses separating from active duty. As a recognized patriotic employer of the New Hampshire Guard and Reserve, we believe that this is a critical component that brings true value to our employees who choose to serve this country. The International Association of Firefighters, on its blog site, which is dedicated to concerns about Replica, states a potential solution is to look at states such as Indiana, which has adopted language to address the issues that the IAFF has. I completely agree. If there are corrections or improvements needed to make this compact better, they should be done through an amendment process and not by fully repealing it, starting from scratch and leaving New Hampshire without any method to participate when needed. I thank you for the opportunity to speak. I am more than happy to work with any subcommittee and offer our views so that we can keep this important piece of legislation in our state. Thank you.
Thank you. Are there questions? Okay. Is there anyone else who wishes to testify on part 2? The subcommittee on this will be next Thursday, starting at 10 a.m. And I will be delighted to have any or all of you participate. No one else appears to be ready to testify, so we will move on. Oh, excuse me, Mr. Odell, my mistake. I wish to testify. Please speak.
Hi, can you hear me okay?
Yes.
Okay, sorry about that, a little technical glitch there. Thank you, Madam Chairman and members of the committee. My name is Clay Odell. I'm a resident of the city of Lebanon. I'm a firefighter, paramedic for the Newport Fire Department, and I'm also a paramedic and a registered nurse for New London Hospital. Full disclosure, I'm a former chief of the New Hampshire Bureau of EMS and also a former member of the EMS Coordinating Board for the state of New Hampshire. I would ask the committee to amend Senate Bill 133 to strike out Section 2, which repeals the EMS compact. And I would ask why the legislature would approve of the EMS compact in 2018 and then repeal it in 2021. Basically, multi-state compacts for healthcare professions are a good thing. They benefit the public and they benefit the providers themselves. As a registered nurse, I benefit from the multi-state licensing compact that New Hampshire benefits from. And it's a good thing for my professional colleagues as nurses, as well as the public who makes a good use of travel nurses and things like that in these days. So I guess, is the EMS compact flawed? Well, my understanding of the compact is no, it is not flawed. The language of RSA 153A and the administrative rules, as well as the rules of the EMS compact governing board, protect the public. I have to say that the driving force behind the repeal effort is the International Association of Firefighters, which is an organization I have high regards for, although I am not a member of that organization. Now, the IAFF has determined that a multi-state compact may be harmful to its members. They're doing their job. They're advocating for their personnel. I completely understand that. The IAFF position is to oppose adoption of the compact in states that are considering it and to repeal it in states where it currently exists. Again, I respectfully disagree with the IAFF and their affiliate, the Professional Firefighters of New Hampshire, in this issue. I would point out that the majority of the approximately 5,600 EMS providers in New Hampshire are not represented by the PFF&H, and I would like to be a voice for the silent majority. I would ask you to keep New Hampshire's membership in the EMS Compact and amend Senate Bill 133 to strike out Section 2. Otherwise, I'm in favor of this omnibus bill. And finally, I would just like to speak to Senator Rosenwald's comment about the compact itself, as far as the farthest distance or the closest distance of a current member being 500 miles. I'd like to point out that the physical therapy multi-state compact, of which New Hampshire benefits, the closest state that is also a member of that compact is in Virginia, and they have 21 states, the same as the EMS compact. And I'm fully supportive of the effort by the audiology and speech pathology and occupational therapy folks to get on board to their organization's multi-state compact. Both of those compacts have significantly less member states involved with that than the EMS compact at this time. So thank you very much. Thank you very much for your time.
Thank you. Representative Schmidt.
Thank you, Madam Chair. Mr. Odell, would you be available for the subcommittee?
I will do my very best. I'm working on the 911 truck today, and the EMS gods have smiled on me and made me available. Same thing for tomorrow, but I will, or whatever date that committee is, I will do everything I can to participate.
Thank you. It's next Thursday, not
Thank you.
tomorrow. Oh, wait, yes, it's included in the other subcommittee. Is there anyone else who wishes to testify on part 2? Seeing none, we'll move on to part 3, and I'd like to call Senator Ward, who is the sponsor. See her with us. Okay. Senator Ward.
I'm here.
Hello.
Thank you, Madam Chair, members of the committee. I'm Ruth Ward, Senator for District 8, and I'm here to introduce Part 3 of SB 133. It has to do with the hearings of the New Hampshire Board of Nursing. The board may hold educative hearings concerning allegations of misconduct or other matters within the scope of this chapter. Such hearings shall be public proceedings. Any member of the board or any other qualified person appointed by the board shall have authority to proceed at such a hearing and to issue oaths or affirmations to witnesses. And that's the content of the Part 3 of SB 133. Thank you, Madam Chair.
Thank you, Senator. Are there any questions? Seeing none. Is there anyone else who wishes to testify on Part 3?
Madam Chair, can we do something about the feedback that's come up It's very interrupting and annoying.
Yes, if everyone who is not speaking, please mute yourself. It will help. Thank you. Lindsay Courtney, you are wished to testify?
Madam Chair,
Yes, Representative Schuett?
excuse me, I did have a question of Senator Ward.
Oh, thank you. I hadn't noticed. Senator, could you
Yes,
ask your question?
Representative Thank you. Senator Ward, was this a bill that was also introduced last year?
you know, I don't remember that was part of the COVID casualty. But I think that Lindsay Courtney could answer that question much better than I can.
Thank you.
Thank you.
Director Courtney?
Thank you, Madam Chair. For the record, my name is Lindsay Courtney. I'm the Executive Director of the New Hampshire Office of Professional Licensure and Certification. OPLC wishes to express its support of Part 3 of this bill and wishes to thank Senator Ward for bringing this forward. Part 3 does remove the prohibition in the current Nursing Practice Act that prevents the public member of the board from serving as the presiding officer over disciplinary hearings. The Board of Nursing is the only board of our 54 boards, councils, and commissions within the office that does not permit the public member to preside over hearings. The Board of Nursing has requested this legislation to standardize requirements across the agency and to permit all members of the board to serve the state in this capacity. As Senator Ward mentioned, any person qualified by the board, including board members or non-board members, other than the public member at present, has the right to serve as a presiding officer. So in a sense, any person in the universe can serve as a presiding officer other than the public member at this point. The presiding officer of disciplinary hearings simply controls the flow and conduct of the hearing and rules on evidentiary motions. The presiding officer does not have authority to make decisions regarding disciplinary actions on behalf of the board. That authority always remains with the board. A quorum of the board must be present to adjudicate cases, and all board members have the authority to ask questions of witnesses. The presiding officer simply facilitates communications, much like the chair of a committee. During last session, to answer Representative Schuett's question, we did hear testimony regarding a similar bill that some nurses were concerned about a non-nurse presiding over a hearing. I do believe that those concerns are based on the mistaken belief that the presiding officer has authority over the outcome of the proceedings. As noted, the presiding officer has no more authority over the outcome of the proceedings than other board members. OPLC supports this bill as it brings the Board of Nursing in line with the other boards within OPLC and permits all board members appointed by Governor and Council to serve the state in this capacity. I'm happy to answer any questions that you may have, and thank you for the opportunity to provide comments.
Thank you. Are there questions? Just Representative Schmidt.
Thank you, Madam Chair. Good morning, Lindsay. So is it not the case that a number of the boards not only permit the public member to be the presiding officer, but in fact, that it's a relatively common phenomenon for experienced public members to be the chair of their respective board?
That's absolutely correct, Representative. And actually, some board practice acts mandate that public members do participate as the chair, which is also typically the presiding officer. Board of Psychology right now, for example, has their public member who happens to be an attorney as the chair and presiding officer. I believe Real Estate Commission has an acting public member. The Board of Mental Health Practice has a public member as the chair and presiding officer, and I'm sure I can provide you with more examples.
Thank you.
No, I just wanted you to say.
Representative Broda.
Thank you. Ms. Courtney, is there a history or an explanation as to why a member of the public would not have been allowed to participate in the past?
So I think it really stems from the notion that the presiding officer has the capability of rendering decisions on behalf of the board. And speaking with some of the nurses, specifically the Nursing Association, who had concerns about this bill last year, there was concern that a person without clinical experience would preside over hearings. My opinion is that that was based on the premise that the presiding officer has substantive authority over disciplinary matters. And if that were the case, I would completely agree that it should be somebody with a nursing background, but that's not the case. But I think that's where the concerns have lied.
Thank you. Representative Schuett?
Madam Chair, good morning, Ms. Courtney. Can you tell us how many members serve on this particular board?
I believe it's 13. It's a fairly large board. We've got 2 public members and then a host of individuals with clinical experience.
Thank you.
Are there other questions? Seeing none, thank you very much. Is there anyone else who wishes to testify on part 3? So raise your hand, please. Seeing none, I will close the hearing on part 3, move on to part 4, and I would call Senator Khan.
Madam Chairman, I don't believe Senator Khan is present. But I wonder, was Senator Carson going to speak to all sections if needed, or how was that?
I believe Senator Carson might be the next best person if she's still with us.
She is, and her hand is up.
Excellent. In that case, Senator, please explain this section to us.
I believe you're muted, Senator Carson.
Sorry, there we go. Thank you, Madam Chair. I will introduce this section. I have to jump off at 11:15 because I've got to introduce a bill in children and family law, but I will come back because it was my understanding that I was going to introduce these different parts, and other senators had asked me to introduce for them. And with that being said, I will have to jump off permanently at noon because I have to be in Concord for a caucus. So that being said, part 4 was a bill that was introduced by Senator Khan. It is a request of the Department of Education regarding a change in the specification for serving roles on the professional standard boards. And in his testimony, he deferred questions to representatives from the Department of Education. Thank you.
Okay. Thank you very much. In that case, are there representatives from the Department of Education who wish to testify? Please raise your hand if so. All right, is there anyone who wishes to testify on part 4? Please raise your hand if so. No? Okay. In that case, we will go on to part 5, of which I am a co-sponsor, so Representative Roy. Call Senator Sherman.
Thank you. Are you able to hear me?
Yes.
Yeah, I'm gonna jump on.
Madam Chair, are you able to hear me? I'm sorry.
I hear you. That's, go ahead.
Okay. Thank you, Madam Chair and the committee. For the record, my name is Senator Tom Sherman, District 24, representing 11 towns on the Seacoast. Part 4 of SB 133 adopts the Audiology and Speech Language Pathology Compact and the Occupational Therapy Licensure Compact. This was at the request of the American Speech Language Hearing Association and the CSG, and has the support of OPLC as well as the boards. As we've heard in earlier testimonies, most of the compacts, and I was involved with bringing the nursing compact to New Hampshire. That was my prime bill when I was a state rep, have been very successful and really helpful in expanding access for patients. This one seems to have the broad support, and hopefully Susan Adams and others will be able to answer any technical questions you have on the compacts. But these are, this is allowing us to expand our workforce without having to expand regulatory component or create unnecessary speed bumps for people who want to bring services to New Hampshire. So with that, I'm happy to take any questions.
Any questions for the Senator? Representative Schuett. You muted.
Sorry, I can barely hear you, Representative Roy. Senator Sherman, I'm seeing section 6 refers to active duty military personnel or their spouses. Would that alleviate some of the concerns about repealing as in section 2?
I'm not really clear. Maybe you could help me with that question.
There were concerns. Thank you. There were concerns about section 2, which repeals emergency medical services, personnel licensure, interstate compact.
Yes.
Section 6 of portion 5, I'm not sure how to
You mean of this compact of part 5?
Right. Refers to active duty military personnel or their spouses. And I'm wondering if that section refers to emergency personnel, emergency services personnel.
Yeah, I guess the answer to a broader question, there has really been no opposition to this bill. We worked with, I made sure that, and I believe the chair knows this as well, the boards have been a part of the process, as have the associations. But this does allow the military component as well. It does cover that. So I think it does answer some of the concerns that may have been expressed in part 2 of this omnibus bill. But as you are probably aware, the vast majority of the compacts in New Hampshire are working very well in achieving the goals that they originally set out, which is to not increase the regulatory burden on providers who already are fully licensed and regulated by another state that participates in the compact agreement. So I guess one answer would be not all compacts are the same. And I think the EMS compact is a separate issue, but this compact really did come with all stakeholders involved in the process and with their support.
Representative Schuett, it's a different compact. So
I understand that, but I'm wondering if it might impact some of the same people, if their professional licensure would extend in these areas. Perhaps some of the other members, some of the folks that testified on that.
Our next witness is from the DOD, so perhaps he could touch on that. Any other questions for the senator? Representative Saitek.
Representative Senator Sherman, this is maybe not to you directly. this is more general education for me. And that's, there is no emergency situation involved in this part as opposed to say part Roman 2. If there's no emergency, why can't we just use regular reciprocity? Why is a compact necessary?
That's a really good question. What is the added benefit? We don't have, I'm a physician. I'm licensed in New Hampshire. I have had to have licenses in every state that I've practiced. So there is really no reciprocity. The beauty of a compact in nursing and this one is that it formalizes reciprocity. And where that really becomes important, I think, is in ensuring competency and also disciplinary action. Because that's the role of our boards, is to make sure that as a physician, I meet the standards of competency, and then it also gives patients the ability to bring complaints or hospitals or otherwise to the Board of Medicine. But in a nursing compact, for example, which we have in New Hampshire, you're held to the same standards, but your license is regulated elsewhere, and any complaints or concerns are typically handled where you are licensed. But it's a super formal process. So a reciprocity agreement, I don't know of any that actually exist in healthcare or in areas that are regulated by state boards, because it's hard to make them formal enough to account for competency and ongoing monitoring of performance. And that's what a compact does. It creates a formal mechanism for both of those to be addressed before someone can practice in the state, whatever their profession is. But you're correct, by the way, this does not have an emergency component, but anybody in any of these professions understands that New Hampshire is challenged by workforce needs. And so being able to bring people, and we're a small state with 3 state borders, being able to bring people from Maine or Vermont or Massachusetts, having them doing cross-border work is not competition, it is increasing a much needed workforce availability.
So Senator, this is basically de facto reciprocity with the disciplinary, if there were a disciplinary issue, where would it be held?
It would be held based on, most of these compacts, any discipline is brought against your license. So you would be regulated by the licensing state, and there will be people who will be testifying after me who are much more expert in specific this type of compact with this specific profession, which is audiology and speech language pathology, as well as occupational therapy. So I would defer a final answer to that to the people who brought this forward.
Thank you, Senator. I think it's actually in the bill. I need to read it more carefully. Thank you.
It is in the bill.
Thank you, Senator. The chair recognizes Christopher Arnold from the Department of Defense.
Thank you, Mr. Vice Chairman, and pleased for the opportunity to speak on Part 5. Committee members, thank you again. I am Christopher Arnold. I represent the Department of Defense, and we are grateful for the opportunity to support the policy changes reflected in subparts A and B of Part 5 of Senate Bill 133. Much like Replica, none of the states bordering New Hampshire have enacted either of these 2 compacts yet. Regardless, New Hampshire should be among the first to adopt these compacts. Maine does have a bill for the occupational therapist compact pending. As the First Lady said a few weeks ago, helping military families with these issues is critical to our national security. From 2011 to 2016, the department worked with all 50 states through common methods used by licensing boards to expedite the acceptance of a license from another state. Many states enacted some form of relief. 39 states enacted laws for endorsement of a current license from another state. 42 states enacted laws for temporary licensure, and 31 states enacted laws for expedited application procedures. However, these methods proved insufficient to address the underlying concerns of military spouses. Further changes to licensure to facilitate reciprocity in state licensure programs for military spouses will continue to take time to cover all occupations in all states. Complicating matters further, terms such as reciprocity and expedited are used differently among the states. The department pivoted its approach in 2017 to consider occupational licensure compacts as another alternative to improve portability for military spouses. Compacts establish common understanding of competency and its measurement within the occupation, and then seek to have states approve the compact through legislation. With this said, all of these approaches can be beneficial if they produce a baseline result of having the military spouse be able to receive a license in approximately 30 days without submitting verifying documentation outside of verifying the standing of the license and fulfilling a background check. DoD has assisted organizations representing occupations with obtaining state approval of their compacts, where these compacts have benefit to the military. These compacts cover approximately 40% of military spouses who need a license to work. Like Replica, these two compacts were designed to enhance the state's ability to protect the public's health and safety, especially client and patient safety. These three compacts encourage the cooperation of compact states in the areas of EMS, audiology and speech-language pathology, and occupational therapy licensure and regulation. The compacts facilitate the exchange of information between compact states regarding licensure, adverse actions, and disciplinary history. Occupations are generally needed to establish a national database of practitioners to operationalize the compact's portability practices. For example, states in the EMS compact share a coordinated data system that enables them to share license history on EMS personnel, including license denials, revocations, and significant investigatory histories. This data system is anticipated to be fully populated by the end of 2021 and is a critical element for states to assure they are issuing licenses only to qualified personnel who have no concerning backgrounds, which I might add would answer some of the earlier questions regarding New Hampshire domiciled service members and spouses who are serving out of states once that system comes online. All three compacts promote compliance with the laws governing practice in each compact state. Finally, the compacts invest all compact states with the authority to hold licensed workers accountable through the mutual recognition of compact state license. The department's 2017 Military Spouse Licensure Portability Examination State Report by the University of Minnesota examined 5 occupations in each state. For occupational therapy, the report found that RSA 332 G-7 requires boards to facilitate the issuance of licenses contingent upon the opinion of the board as to whether a spouse's previous requirements of licensure are substantially equivalent. But for occupational therapy, that certain spouses must apply for new licensure as though they are a new applicant, and that those who do hold active licenses in other states must submit verification of their previous licenses, a time-consuming process that can take months. The department advocates that to achieve immediately attainable actions, near-term actions, and long-term solutions, they be pursued simultaneously to gain as much flexibility for military spouses in the near term while preparing for substantially improved portability in the future. As a result, the department anticipates the cumulative impact of these processes should represent a more significant impact. For example, if processes that implement statutory changes for military spouse licensure are in place, they will greatly enhance the impact of further changes to policies that allow military spouses to obtain a license in 30 days without submitting verifying documents. Likewise, while these initiatives get military spouses to work more quickly, compacts can provide seamless reciprocity for military spouses in an occupation. EMTs, occupational therapists, audiologists, and speech pathologists can move from a compact state to another compact state without any relicensing. When they move to or from a non-compact state, then having the 30-day without submitting verification approach can help get them to work faster. Consequently, engaging in state-only licensure reform simultaneously with improving interstate relationships through compacts provides for optimum access by military spouses. We appreciate the opportunity to support the policies outlined in the Audiology and Speech Language Pathology Interstate Compact and the Occupational Therapy Compact introduced this session, and thank Senator Sherman for his leadership and his sponsorship. Joining these compacts will allow military personnel and spouses to more easily maintain their certifications when relocating. Please feel free to address whatever questions you may have. Thank you.
Representative Schuett.
Thank you, Mr. Chair. Thank you, sir. You probably heard my previous question about whether this portion of the compact would alleviate some concerns for military personnel and their spouses. Reason for my thinking this is my particular town has EMS services, but most of the employees there are part-time. And I know of 2 of them, in fact, who work full-time as physical therapists. So my thinking was that if you are involved in the medical professions, you might tend to have those overlying capabilities. Do you know if any of the people who would be involved in EMS services would also be physical therapists or apply under this compact?
So to the extent that a person may hold 1 or more professional licenses, certainly if they are a physical therapist relocating from one compact state to another compact state, that compact is of benefit to them. However, if they are also a paramedic or an EMT, and they are relocating from a compact state to a non-compact state, New Hampshire's leaving that compact would be highly detrimental to that individual. I might add, it would also, to speak to the question about disciplinary actions, be detrimental to the state, in that repealing replica would mean the granted state gives up its ability to suspend or revoke an out-of-state EMS person's privilege to practice in New Hampshire. Under that provision of the EMS compact, New Hampshire has full control over its ability to suspend or revoke the privilege to practice of an out-of-state person functioning in New Hampshire under the compact's privilege to practice. If New Hampshire or any other state revokes a person's privilege to practice, that person loses that same privilege in all other compact states. In addition, the home state that issued the person's license would agree to investigate whatever infraction led to the revocation of the privilege to practice as if it happened in the home state. Accordingly, a person could lose their home state license based on something they did out of state. And similar protections are in place for both the Occupational Therapy Compact and the Audiology and Speech Language Pathology Compact contained in Part 5.
Thank you. Representative Goley.
Thank you, Mr. Chair, and thank you, Mr. Arnold, for taking my question. Today, I understand correctly in your testimony in the beginning that the Department of Defense was specifically looked at starting compacts to alleviate issues with military personnel who have been moved or are looking to go into be removed from service.
Roger, so that is correct. And if you go back to the 2019 National Defense Authorization Act, there was in fact a requirement for the Secretary to enter into a cooperative agreement with the Council of State Governments and their Center for Interstate Compacts for the development of new interstate occupational licensure compacts. And in fact, 3 weeks ago, there was a press release from the Secretary because there had been $5 million to facilitate that process, announcing 5 new occupations that had been selected to develop interstate compacts, including teachers, dentists and dental hygienists, massage therapists, cosmetologists. So as you can see, this has been sort of identified on our continuum as the optimum means for pursuing reciprocity. That being said, there is not a compact for every occupation, nor is every state a member of each compact, which is why we advocate for a variety of solutions simultaneously. Thank you.
Follow up?
Yes, go ahead, follow up.
Would you be supportive of compacts being specifically for military personnel and spouses versus opening it up to everyone?
Roger, so to the extent that the work goes into drafting a compact, it brings together stakeholders from the occupation, and the qualifications in the compact are defined by an advisory group and a drafting team composed of state policymakers, practitioners, state board members, to develop a balanced set of standards for portability that would apply to all practitioners. So in terms of getting that team together for drafting to focus on protecting public safety of consumers and appealing to the vast majority of states in order to be positively considered, we would support the approach that fulfills those goals.
Follow up?
Follow up.
So that being said, it obviously would be the professionals of the board that would be setting the standards for the compact. Would you be in favor of the compact slowly being in place for those military individuals that we've talked about, the Department of Defense is looking to cover?
I'm sorry, so I'm not sure if you're referring to a compact that only applies to military personnel, but we're talking not only about active duty service members, but also their spouses, recently separated veterans, reservists, and guards person as well.
That is correct, and that's what I'm talking about, covering all those individuals.
Roger, and compacts do, which is why we found them to be an optimal approach.
Thank you.
Thank you. Any further questions for Mr. Arnold? Seeing none, I will recognize Senator Sherman. You have your hand up.
Yes, I just wanted to address Representative Sytek's question. I had to go back and into the bill, and the way to think about this, first of all, to think about this is that there is basically a home state and where the person is actually practicing or providing services. And so in the state in which the person is providing services, that's while the person is providing services, they are subject to all, and the way the bill reads, the state laws, due process, and all of the activity of the state's regulatory authority. So, and the action that that state may take if there is a disciplinary concern is to revoke their compact privilege in that state. And then they also notify the home state. So just to clarify, the home state holds the license and could use action by another state's board if they wanted to, and to encumber the license. And when a license is adequately encumbered, or there's concerns, the person can lose their compact privileges in other states until that license is cleared. So I hope that answers Representative Sytek's question where the disciplinary process lies. So that's really good news for New Hampshire, because if you have somebody coming from a compact state, then that person is practicing in New Hampshire and they are subject to the boards in New Hampshire for their compact privileges. Those boards cannot impact directly that person's license, which is held in the home state. But this has worked very well. And just briefly addressing Representative Goley's concerns, these are all state boards. They're non-military boards that oversee this. I would think it would be, the goal here is to allow people to practice in multiple states, whether they're military or not, without having to be encumbered by multiple licenses. And it has been incredibly effective in the nursing boards and many of the compact arrangements that we already have But it would be, I would think it would be very difficult to do this for just for military, because the boards are civilian boards that oversee all of these licenses. And I would urge you to approve this section 5, so that it can move forward and allow for really increasing the reservoir of people who are available to work in the state of New Hampshire.
Thank you, Senator. Anyone else wishing to testify on this bill?
Mr. Chair,
Yes, go ahead.
I have a
Representative.
hand up.
Oh, I'm
Question.
sorry. My computer actually died, so we're sharing one with. Go ahead.
Just a quick question for Senator Sherman, if he'd take it. If he's
Senator
still
Sherman,
on.
are you still there? I don't see him. The chair recognizes Tina Kelly.
Can you hear me?
Yes. Go ahead.
Good morning, Madam Chair and members of the committee. I'm Tina Kelly, appearing on behalf of the Office of Professional Licensure and Certification, support of Part 5, the Audiology and Speech Language Pathology Compact and the Occupational Licensing Compact. An individual who holds a license in a member state will be issued a privilege to practice in this state. These individuals holding a privilege to practice are required to follow the scope of practice of the state of New Hampshire where the patient client is located. In addition, holding the privilege to practice will subject to all laws and rules of the state where the patient is located and can, if necessary, suspend that privilege to practice in the state of New Hampshire. These compacts will allow ease of mobility between states while keeping all safeguards in place. This includes all types of military, anybody who has the appropriate training. This will ensure standard requirements for licensure across compact state. Those requirements include things like education, examination, verification of states where the person has worked, background checks. A person licensed in a compact state who wishes to practice in another compact state will not be required to resubmit these documents in each state, reducing the time and cost to that person. These compacts will ensure boards retain all authority they currently have over those practicing in the state of New Hampshire, whether or not the practitioner is practicing here under a New Hampshire issued license or a compact. These compacts will allow cooperation and communication across state lines with regards to investigations. In conclusion, the passage of this portion of Senate Bill 133 will allow for ease of mobility, ensure standardized licensing requirements, and the ability to investigate and take disciplinary actions against the privilege to practice when necessary. When putting this compact forward, we cannot change the language of this compact because then we would not fit in with what the other states do, and it wouldn't work to tweak the language of the compact to change it to just one type of person or somebody who might be in the military or somebody who's not. This is designed to benefit all individuals who are occupational therapists, occupational therapy assistants, speech language pathologists, audiologists, anyone in those professions. So with that said, I'd be glad to take any questions you might have.
Thank you, Representative McGuire.
Thank you, Ms. Kelly. Is it essentially the case that by joining a compact, the board is deciding that the requirements for licensure required by the compact states are equivalent to those of New Hampshire?
That is correct. When a state adopts or passes legislation to become part of the compact, they're accepting baseline requirements. That would be a standardized education, a standardized exam, so that every state going into the compact has the same requirements to become licensed. And all the states are agreeing that that is where the initial requirements should be for entry into the profession.
Thank you. Representative Fellows.
Thank you. My question is, the compact, except for military personnel, a person who moves from another state and is initially certified based on their home state license, once they move to New Hampshire and they're a resident here, when it's time for renewal of what was their home state, they have to renew in New Hampshire. Can you tell me the length of the license? How often do audiologists and speech pathologists have to renew in other states and also in New Hampshire?
Okay, so states are different with their renewal, but let me start at the beginning of that. What happens is you have your home state. You have your license there, you get your privileges to practice in other states. If you leave that home state, you have to, wherever you're living and whatever is your state you reside in, you have to have a license there in order to have those privileges to practice. So if you leave that home state, you have to get another license and then reobtain your privileges to practice. Because the compact doesn't know whether you'll move to a state that isn't part of the compact or is part of the compact. So once you get that license in your state and you're the home state and you're going to renew, you would renew based on theirs no matter what the other states do. So in New Hampshire, it's every 2 years. So if the person is here and licensed here and getting privileges to practice from here, they would still renew every 2 years in their New Hampshire cycle.
Thank you.
Any other questions for Ms. Kelly?
Yes.
Yes, Representative Lakis.
Thank you, Mr. Vice Chair. What I'm wondering is how do the compact's requirements for the various licenses compare to the existing ones in New Hampshire? I mean, do ours have less requirements, more requirements? How do they compare?
Our requirements currently line up exactly with the requirements that are in this compact.
Okay, thank you.
Representative Saitek.
So I'm kind of Johnny one note here, except for what I heard earlier about people coming in on a freelance basis for occasional work. With that exception, this is super streamlined reciprocity, is it not?
Yes, it's reciprocity while still ensuring one of the big components of having a compact is the ability that if somebody has a privilege to practice here and they have a license in their home state and they were to do something here, we could remove that privilege to practice, but we can also work with the other state or states if they have more than one privilege to practice in any type of investigation.
Thank you. I'm happy.
Representative Pearson.
Thank you, Mr. Chairman. Ma'am, it's so if I'm understanding you correctly in what you said about the changes and how language cannot be tweaked, if the state of New Hampshire had something, a circumstance that was unique or some sort of situation where the folks in New Hampshire thought the standards should be a little bit more stringent, or there was a specific item to New Hampshire that we wanted to put in to those protocols, would then we now be restricted because we are part of this multi-state compact from being able to do so?
Okay, so once if this legislation went through and New Hampshire decided that there was something that needed to be tweaked with the compact, There's the Compact Commission, and New Hampshire has a seat on that commission. And you would take the concerns there, you would discuss it, and as a group, the group would decide whether or not that would be something that needed to be changed. If New Hampshire felt strongly enough that, you know, whatever it was not protecting our citizens, we'd have to go back and repeal the compact. And but
So your short answer is no. We would not be able to do that.
that's correct. But one of the things on getting in on the ground floor of these compacts, when they're in their formation stage, New Hampshire would have a seat at that table in forming the compact rules.
Thank you. Representative Grota. Representative Grota, you're muted.
Thank you. Ms. Kelly, we do have reciprocity with other states, with other professions, and we have compacts as well with other states. We're part of compacts, is that correct?
That is correct.
And why would we choose one over the other?
As far as reciprocity or a compact?
Correct.
So it's very difficult with reciprocity to determine sometimes whether or not some standards rise to the same standards as New Hampshire. And it's very time consuming to go through every state to make that determination. And then even though you've made that determination, a state can just change something which may take them out of alignment with what New Hampshire does. With a compact, you're all in agreement, you're all in it together. So you don't have to worry that tomorrow another state will change their requirements and possibly have somebody who's not qualified come into the state and practice.
Follow up?
Follow up.
Thank you. How is, so this discussion on compact, who supervises how people who are coming into the state under this compact are actually, let me rephrase that. Could I rephrase the question? Does this compact therefore replace the function of OPLC or the boards? How is that, how does the function of the compact and the regulations within the compact affect how OPLC works in, you know, during its standard day?
It would not affect what the board or OPLC can do at all. What the compacts at a higher level, it's basically the licensing requirements, the licensing of a person, not scope of practice within the state that the patient or client is located, not the laws and the rules of the state of New Hampshire. If somebody's here practicing on a patient client located within the state of New Hampshire, they have to follow all of our laws and rules as they stand right now. The only difference is that they're coming and they're getting a quicker license to come in and practice. One of the things that it does regulate is if we were to take away the privilege to practice, or another state were to take away a privilege to practice, they lose all their privileges to practice until it's resolved. So there's that safeguard that somebody won't lose it in one state and still be practicing here unsafely.
Okay, and could I have one last question, Mr. Chair?
Yes, of course.
How do we know that this person has lost their license in another state? How is that communicated to us?
And I can speak to what I've seen. I was involved in the PT compact, and these two are basically the same. The PT compact has been working very well, and when somebody gets disciplined or something happens in another state, that compact commission notifies the state of New Hampshire, notifies the board with written communication that something has happened.
Thank you.
You're welcome.
Representative Goley.
Thank you, Mr. Chair. Thank you, Ms. Kelly, for taking my question. I heard this similar response when we were looking on the replica bill. I hear you say that we need to do this so we can have a seat at the table. Can you tell me how many people are at that table when we get a seat at it?
That I'm not sure. There is a threshold that has to be met in order for the compact to be formed. And I want to say 15, but I'm not sure. It's right in the compact language itself. I'd have to look it up. But once that is met, then the compact states with a representative from each state come together and they set the rules of how the compact will be, how it will work. Like, you know, the database will work, when notifications of discipline are sent out, all of those things. It sets those procedures so that they're formulated right in language. And it's always good to have a seat at the table when those things are initially being formed. That way, if you come into the compact later on down the road, they're already formed and you have to go through a different process to get anything changed. Does that?
Follow up?
Follow up.
So my question is, if we're one of, say, 15, and even though now that we're in this, we don't agree to something in those procedures, we have to go through the whole process of what we're looking at on repealing replica to get out, correct?
That would be correct, but I will say that, like I said before, the PT compact was enacted, I'm thinking 4 or 5 years ago. We got a seat at that table when that was being formulated. It's basically the same type of compact. And I can tell you right now, the PT compact works wonderfully. It's been very beneficial. The people on that compact commission, they work very closely, work together, and their goal is protection of the public.
Follow up?
Follow up.
And just because we have the initial seat at the table doesn't guarantee us a seat at the table forever on that board. I would imagine that it would rotate through.
That would be every state who's part of the commission has a seat at the table. When they come on, they automatically get a seat. It would be the officers that may be rotated. There may be 5 or 6 officers, you know, a chair, a vice chair. I'm not sure how it's going to be, but it would be that similar structure, just like a board would work.
And one last follow-up.
Last follow-up.
So as the numbers increase or the makeup of the seats at the table changed, the initial seat at the table that we had in making these rules obviously could change and may not to be completely to our liking. We may not agree to everything that is in there further on down the road, correct?
That could happen, but we get a vote on whatever changes would be made. We always have a vote. We always have a say. And so, yeah, it may not be to our liking, but the core requirements for licensure and the core outline of what it is going to look like to be part of that compact is in legislation. So I don't anticipate there would be anything that could be put forth that would be so detrimental that the board or the state of New Hampshire would see that as something that would push them forward to get out of the compact.
Thank you.
Thank you. I'd like to just ask a question for myself, if I may. If, let's say that during an annual meeting, a proposal is made that New Hampshire does not agree with, could you explain the process, how that would work, and how we could avoid that?
So if we didn't agree with something that was being put forward, it would be just like on a board. You would discuss it with all the other members, with a representative from each other state, all the members, and it would be majority vote. But like I said, I don't see, because the core and the basics that really structure this are in this law. I don't anticipate there would be anything that would come out of this that would be so detrimental the board would feel that it was necessary to get out.
Thank you. Representative Lakero.
Thank you, Mr. Chair, and thank you for taking my question. This may have been answered already, but there's a lot to digest in this, so I'm going to ask again in case it hasn't. Suppose something came up, there was a change in the board meeting. At the board meeting that New Hampshire found to be an irreconcilable difference. Is there a penalty for any compact member to just throw up their hands and get out?
Well, if we were to get out of the compact, if we were to repeal this legislation once it's enacted, then anybody who had a privilege to practice would lose that privilege to practice. And they would have to go and get licenses from each state that they wish to hold a license in.
Well, so then in other words, we would just be back to where we were without the compact. It's other than that, there's no detriment to just throwing up our hands and leaving if we found it necessary.
Correct.
Thank you.
Representative Sitek.
I'm getting the analogy here that the compact is really a super OPLC. You don't have anything to do, the compact will have nothing to do with the scope of practice, which is the thing that would concern me most, right?
That's correct. When somebody's practicing in this state, they have to follow all the laws and rules, and that would be everything that's currently on the books. They have to follow everything or the board could take action.
Representative Grote.
Thank you, Mr. Chair. Ms. Kelly, if we wanted to know which compacts and which reciprocity agreements we have in place, where would we find that information?
We could get that from OPLC.
Would you be able to provide that to us, please?
Yep.
Thank you.
Representative Pearson.
Thank you, Mr. Chair. My inquiry involves liability and insurance. Currently, depending on your profession and whether or not you're a government employee, there are certain insurance policies for various things, negligence and malpractice and whatnot. Now, with this compact that you're talking about, these folks are going to, is it fair to presume they're not going to be covered by their insurance automatically in other states? Are we looking at a situation where folks, if they decide to be involved at this level, or they would have to expand the insurance that they carry to cover them practicing outside of their home state?
I do not have any idea. I would imagine that they would have to, because all insurance companies are different and coverage is different, they have to contact their insurance company to see what it exactly covered and what they would have to do.
Thank you.
Ms. Kelly, I'd like to ask a question with regard to the insurance that just piqued my interest. Does New Hampshire currently cover or require insurance for this profession? And as part of the compact, people would have to comport themselves to New Hampshire requirements. They would, by necessity, have to obtain insurance. Is that correct?
From what I understand from the board's administrative rules, there is no requirement in those administrative rules that dictates what insurance somebody should carry or must carry.
But if New Hampshire requires insurance to practice in our state, you have to follow the rules of the state you're in. Would that not mean then that you would need to have insurance?
That is correct.
Thank you. Representative Grote, follow-up? You have another question?
Oh, I'm so sorry. I forgot to lower my hand. Apologies.
Okay. Representative Sitek.
You'll see where I'm going with this question. Have we had any bad experiences with our participation in other compacts?
I can't speak to all the other compacts. The one compact that I've been involved with is the Physical Therapy Governing Board's compact. And from everything I've known, and I was in that from its inception, involved in that, I have not seen anything that we ran into that was any kind of an issue at all. There might have been one thing at the very beginning with licensees, and it was to do with insurance, but I think it was Medicare or Medicaid, and that was all worked out. I have no idea what it was, but I know there was a little glitch. The Compact Commission worked on it. It was all resolved. And once those get resolved, they carry through to other similar compacts. It's my understanding.
Thank you. Any further questions from Ms. Kelly? Seeing none, thank you, Ms. Kelly. The
Thank
chair
you.
recognizes Susan Adams.
Thank you, Mr. Vice Chair and members of the committee. My name is Susan Adams, and I'm the Director of State Legislative and Regulatory Affairs for the American Speech Language Hearing Association. And I'm here to ask for your support of Senate Bill 133, Section 5, the Audiology and Speech Language Pathology Interstate Compact. ASHA began this project with the Council of State Governments in 2017 to develop an interstate licensing compact for our members. At that time, we met with a number of state legislators, state licensing boards, state associations, and other stakeholders, holding hundreds of phone calls and webinars to discuss the compact and how it could work. As you've heard from Mr. Arnold, we work specifically with the Department of Defense on language related to military and military spouses. The ASL-PIC is designed to allow audiologists and speech language pathologists to practice across state boundaries through telepractice and in person, both legally and ethically, without necessitating an individual become licensed in every state. And it increases consumer protection by expanding the prosecutorial net for bad actors. It's very similar in form and function to the current occupational licensure compacts for medicine, nursing, psychology, and physical therapy. We now have 10 states that have passed the legislation, which is the threshold for the Compact Commission to begin operations. Those 10 initial member states are Alabama, Kansas, Kentucky, Louisiana, Oklahoma, Nebraska, North Carolina, Utah, West Virginia, and Wyoming. In addition, Georgia and Maryland have passed their legislation, and it's awaiting signatures by their governors. Given that we have the 10 states that can begin operations, we don't expect a commission meeting to be held until probably the fall. So any states that pass the legislation between now and then would also have a seat at that initial meeting. And that's the meeting where the rules and the bylaws for the compact will be developed. So those states that are sitting at that table will have probably the most influence on what goes into those rules and bylaws. It's unlikely that those rules and bylaws will change much, if at all, once they're developed by the states. And other states are expected to take those rules and bylaws in addition to the compact language in and be able to follow those once they join the compact at a later date. So I hope we can count on your support to move this bill forward so that we can increase care for the residents of New Hampshire with communication disorders. And I'm happy to answer any questions you may have and can be available to the subcommittee if needed.
Any questions for Ms. Adams? Representative Seidel.
Do you have any sense, thank you. Do you have any sense of why Pennsylvania, New York, Vermont, Massachusetts, places a little closer to us have not gotten into this? Why are we the guinea pigs of the East Coast?
Thank you for your question, Representative. States really have a variety of reasons as to why they haven't joined the compact. Massachusetts, for example, has an issue that they're working on that's very important to them, and that's licensure for clinical fellows. They're the only state in the country that doesn't license speech language pathology clinical fellows. So they really want that legislation to pass because they've been working on it for so long before they take up a new issue, so to speak. Pennsylvania is interested. We are hoping that we'll get a bill introduced there next year. New York, for example, just doesn't generally like compacts, and they're one of those states that hasn't joined any compact. So they're probably not going to be the front runner. They're going to be probably the last state to join. So this is only our second year in state legislatures. And, we certainly are working for this to become a 50-state compact. So we will, keep approaching those states in the future to get them to join also.
Thank you.
Any further questions from Ms. Adams? There being none, thank you, Ms. Adams. Anyone else wishing to testify on section 5 of SB 133, please raise your hand. There being none, I'm going to close the hearing on section 5 and return the gavel back to Chairman Dwyer.
Yes, thank you. I actually was an error. I'm not a co-sponsor of part 5. Part 7. So it being afternoon, we will break for lunch. We will resume at 1:30, picking up with section 6, which is the music therapists. All right. We'll take a break and we'll mute the committee room.
You're muted now.
bit of strapping and fortified with coffee this time.
Fine, Bill, let me walk out.
I'm gonna have to look back at the old one to see if it confirmed my impression. There's two big blocks, miles apart.
Yes. We've got another minute or two.
Yeah. And my official DNA form, we have two. I found it online.
Oh, it wasn't initially. The NHOA.
Yes, I recognize.
Very hurt that I wasn't given 100%. Don't you get a handicap? Like for being a rookie?
No, no.
I know you're 98.5. I'm on top of that.
Good afternoon, everyone. Welcome back to the hearing on Senate Bill 133. Ms. Smarling, were you able to get in touch with Senator Avard?
Senator Avard was actually here all morning and he did not come back. So I can give him a call right now. I thought he would return.
Okay. If not, we have one of the co-sponsors.
Right.
In that case, Representative McGee, if you would care to introduce this section of the bill since you're co-sponsor.
Yes.
And
Oh, go ahead.
please remember that we have heard your bill on music therapists and we heard all the testimony, so you don't need to repeat. I would hope it would be, this should be a fairly brief section. Thank you.
Yes, thank you, Madam Chairwoman, and thank you, members of EDNA. I'm Representative Kat McGee of Hillsborough 27 Hollis, and I'm here today representing my constituent who is a board-certified music therapist, Shannon Lane, who is the current Director of Music Therapy and Adaptive Lessons in Early Childhood at the Manchester Community Music School. She was the first person to bring me this issue, and I had submitted a bill to this committee in the last session, which was one of the predicating reasons for the bill that's before you today. So I only bring that history up because that bill was heard by this committee in January of 2020, and then there was a subsequent subcommittee, and the language resulting from the 4 meetings of that subcommittee evolved into the language that is before you on pages 38 to 41 of SB 133, which is section 6. And that is the licensure and regulation of music therapy. So let's see, the committee's quite familiar with the bill, as the chairwoman already mentioned. And and the content. So I'm not planning to go over anything about RSA 328F on allied health professionals. And I believe Marissa Scott is here to answer any questions about the profession for herself or her colleagues. I can just say that as I've grown in being a member of the House, I've learned about the process of lawmaking. And I believe that one of the most inspiring aspects of our work is really to watch people step up and let their representatives know what it is that they need from us, and then teaching us what we don't know. I've learned a great deal about music therapy and about the caring professionals who use this form of therapy to transform their clients' lives with tailored plans and quantifiable goals. And I just relate this to, I broke my wrist in 2018, and I ended up working with a pair of hand therapists at Apple Therapy in Nashua. I started out with little to no mobility, and strength was not even on the menu. So I have some understanding for what it means to have a significant disability that needs to be tended to by someone who actually understands how to nurture you through the process. And that is how I relate to what I have learned about these certified music therapists. So just imagine how a board certified music therapist is uniquely qualified to do that type of therapy, meeting a client with neurological or developmental limitations where they are, and then gradually moving them towards greater functionality. It's noble and unique work, and these talented patient professionals want to be legitimized for the education that they undertake and the caring that they display in doing meaningful work for the clients they serve. This is not a therapy that detracts from other forms of therapy. It's a specific form of therapy that is applied when it is the appropriate choice. And just like I would not see a back specialist when rehabbing a broken wrist so that I could regain use of my dominant hand, this particular form of therapy, I think its time has come in terms of being added to the allied therapies that are available to people in New Hampshire. And I'm sure you'll hear more on that later today. So I hope that you can see your way clear to passing Section 6 of SB 133 here today to save us all from doing it again, because in case you haven't noticed, these music therapy folks are very determined. They're not going to stop until they can find that they have the licensure and regulatory supports that they require.
Excuse me, Representative McGee,
Yes.
are you threatening us?
Well, at this point, I feel it. There's no harm. No harm, no foul. No, I am not. But I think I want you to understand how much determination the people that I have met in this profession have shown me. So I'm sure that they'll be back again if it doesn't go through this time. So I just thought I'd let you know that. And that's it. If there's anything else I can answer for you, I'd be happy to.
Okay. Other questions from the committee? Seeing none.
Thank you.
Thank you, Representative McGee. Is I still don't see Senator Avard. So,
No, I have not had success contacting him. I've tried.
okay. Marissa Scott, I think, is the. Yes, there she is. Okay, we will bring her in and.
Hello.
Hello. Please introduce yourself and keep your testimony brief because we've already heard about music therapy earlier this year.
Yes. Thank you, Chairwoman McGuire, and thank you, members of the committee. So I'm Marissa Scott, and I want to thank you for your listening ears today. I know you're very familiar with our portion of the bill. I'm speaking to you, of course, on the behalf of the New Hampshire Task Force for Music Therapy State Recognition. I'm also a board certified music therapist, and I'm a female business owner in the state of New Hampshire. I live in Dover, where I run my business with my husband and my 4 kids. And I I've previously come to you before to discuss the licensure of music therapists and specifically how it will help constituents by increasing access to services and allowing constituents to find a qualified provider. We do have several instances right now of people saying, you know, oh, I do music therapy, and they have no education and training. So that's just really wanting to protect the education and training of a music therapist, and also, you know, protecting the constituents. And so since I've already spoken at great length on this topic, I would like to be mindful of your time, but I wanted you to know that I am here. I'm happy to answer questions. And I participated fully in the Senate hearings, and there was no opposition to our section during the Senate process.
Thank you. I had a question when we heard the Representative McGee's House bill. The speech language pathologists were still concerned about the scope of practice in music therapy. Has that been resolved?
Yeah, so I think part of thank you for your question. The part of the problem was that the American Music Therapy Association and the American Speech Therapy Association are communicating with each other at the national level. And they have agreed upon the language that's being put forth in the bills that are going out in different states. And it doesn't always trickle down to the state level in time, but we have what is in this bill, the agreed upon language between AMTA and ASHA. And so it's just a matter of communicating at the state level as well. We're open to communicating with them, but the language in this bill was what both agencies agreed upon.
Thank you. Are there any other questions? Okay. Seeing none, thank you for your testimony. Ms. Susan Adams. Pardon us, we're having a little technical difficulty in training our, since Representative Roy has had to leave this afternoon.
Madam Chair, can you hear me now?
Yes, thank you. Sorry about the delay.
Thank you, Madam Chair, members of the committee. My name is Susan Adams, and I'm the Director of State Legislative and Regulatory Affairs for the American Speech Language Hearing Association. And I'm actually here to ask for amendments to this bill because the language that has been presented is not language that has been agreed upon by all the parties involved. And in fact, there is no language that AMTA and ASHA have agreed upon. So the language presented to you as being agreed upon by all parties is not true. ASHA doesn't oppose the licensure and regulation of music therapists, but we are concerned about infringement of scope of practice for speech language pathologists. Although a music therapist can and does treat individuals with communication disorders, they're not qualified to treat the communication disorder itself, which falls solely under the scope of practice of SLPs. SLPs are uniquely educated and trained to assess and treat speech language swallowing cognitive communication disorders in children and adults. These services help children acquire language and enable people to recover essential skills to communicate about their health and safety, to swallow adequate nutrition safely, and to have sufficient attention, memory, and organizational skills to function in their environment. We have worked with music therapists in other states to clarify this language so that it's clear that although they can treat an individual with a communication disorder, that work is related to communication skills and not treating the communication disorder itself. I hope we can share language so that New Hampshire can include this also to ensure that there is no confusion as to which professionals provide which services. I'm happy to answer any questions and be available to the subcommittee.
Thank you very much. Are there questions? There's one there. Representative Schmidt.
Thank you, Madam Chair. Good afternoon, Ms. Adams. I'm wondering whether the language that you are asking us to consider was offered to the Senate in the course of the development of the bill.
Thank you, Representative Schmidt. It has not been offered in the Senate yet because the language was just agreed to in Maryland in the last couple of weeks. So it was it occurred after the Senate hearings.
Follow up?
Follow up.
When you say agreed to, you mean that you and the music therapist organization, your organization and theirs agreed to it, that language in the state of Maryland?
Yes.
Thank you.
Representative Baroda.
Thank you, Madam Chair. I guess this question could go to either Representative McGee or Ms. Scott. We had a subcommittee last year on this bill, and we met, and there was a woman, I believe her name was Ms. Chesterly, who was part of that subcommittee work. And we had come to an agreement regarding an amendment on this bill. So I wanted to know, is this language that, so I'm not sure if Ms. Adams is up to date on that. So is this language that is being discussed different than that?
Yes, Ms. Scott, can you answer that question?
Yes, thank you. Representative Grote, this language in this bill is directly pulled from our discussions in the subcommittee. Our subcommittee discussion result was that there's already a prohibition against music therapists using or engaging in the practice of audiology or speech pathology. It's in their licensure. It's in their scope of practice under their RSA that prohibits anyone from doing anything in the such where they would be doing their scope of practice. And so it would be redundant and repetitive to put it in our bill as well. And so it was agreed upon in the subcommittee meetings that it was not necessary to put it in this bill because it's already in their bill that you cannot act as a speech or audiologist. Sorry.
Follow up, please, Madam Chair. So Ms. Adams, this language that you're referring to as an amendment describes what, per se?
It makes it clear in the Music Therapist Practice Act, which would likely be the only one that a music therapist would read, that they are not able to treat a communication disorder itself.
Thank you. Are there other questions? Is there anyone else who wishes to testify on part 6?
I have a question. Will Ms. Adams make that language available to us?
Yes, absolutely. I will send it to the committee chair if that works.
Yes.
Thank you.
I call Tina Kelly. You should be able to unmute yourself, Ms. Kelly.
Okay, can you hear me now?
Yes, indeed.
Good afternoon. I'm Tina Kelly. I'm appearing before you on behalf of the Office of Professional Licensure and Certification. OPLC does not oppose nor support this bill, but we do, however, have some concerns, and I believe I've testified to these before. But one of the concerns is that on page 38, line 11, it adds those definitions listed there to RSA 328. Those specific definitions should remain solely in RSA 326M, the proposed legislation. Because if it's put into the allied health law, they would significantly change the meaning for the other allied health boards. The appropriate changes are described on page 40 in line 22, and those are being added. The second thing is that this bill is being added to the allied health boards, which are fully autonomous boards receiving administrative support from OPLC. On page 40, line 14, it states under Roman numeral 3, the executive director shall seek the advice of the board for issues related to the regulation of music therapists. Because of this requirement under their duties, it's unclear whether this is meant to be an autonomous board or an advisory board. And the last thing I'll add is that we wanted to be sure that on page 41, it creates a new position if this legislation were to pass. And OPLC would definitely need that position. Although there wouldn't be a lot of these of licensees, there's much more that goes into administering a board: development and maintenance of rules, meetings, replying to questions of the licensees and the public, maintenance of a database. So if this does go through, we would definitely need that position. This is all I have at this time. If you have any questions, I'd be glad to answer them.
Representative Broder, you have a question?
Thank you. Ms. Kelly, in regard to the new position, isn't that, won't all organizations all new organizations in OPLC have the same requirement, so that it wouldn't, how is it that, does that mean that for every new group that was brought under OPLC, you need a new position to initiate all those changes?
Not necessarily, but in this case, we've added so much to our staff that are already doing the licensing that at some point it becomes, although our staff does a great job, they're just overwhelmed with the amount of licensees. So adding even a little bit more is just going to create that much more work. And at some point, every little bit becomes unsustainable.
Yes. Representative Broder, if the board already exists and is moved to OPLC, its staff would move with it. This is a brand new board, so their position is that they need staff.
Thank you.
Representative Schuett.
Thank you, Madam Chair. Not sure who to address this question to, but do we have an idea how many people would be likely to apply for licensure under this grouping?
When we were discussing the House bill, it was between 30 and 40.
Thank you.
Other questions? Is there anyone else who wishes to testify on part 6? So please raise your hand. Not seeing any. Close part 6, move on to part 7 and Representative. Oh, Grant Fossey.
Hi there. I apologize, Madam Chair. I didn't have a raise hand button, so I just thought I'd unmute myself. I am here on behalf of Senator Kevin Avard. I am Grant Bossy, Majority Policy Director for the New Hampshire Senate. I apologize for my tardiness. Senator Avard had hoped to be here himself. He is the prime on this section of the bill. He will be submitting written testimony to you and asks for your consideration of that. And other than that, he apologizes for not being able to be here in person and would appreciate the committee's consideration.
Thank you. Glad he sent someone. All set. I do want to make one administrative comment before we go on to section 7. That is that part 2, which is on a compact, will also be considered by Representative Roy's subcommittee on the occupational therapy and audiology compacts, since they're somewhat related. Hope it doesn't bother you, Representative Kukovich, to lose that section, but he volunteered.
I'm going to open the hearing on Part 7 of Senate Bill 133. Is Senator Reagan here?
Senator Reagan is not here, and I have reached out to him by email and phone and have not succeeded in contacting him, just so you know.
So thank you. Representative McGuire, would you like to introduce the?
Yes, certainly. This is more technical cleanup on the OPLC. This deals with hearings, the administration of hearings and application procedures, and it includes the rulemaking authority of the department. Again, this is a lot of very fine print that we will be examining closely tomorrow morning. I believe it is all essentially duplicative to existing law, except that it consolidates these activities under the OPLC rather than each individual board. Try to answer questions.
Representative Grota.
Thank you, Mr. Chair. Is this then similar to House Bill, is it 58, the one that Senator Carson submitted that has a similar tone?
Yes, except that Senate Bill 58 deals with different topics that are consolidated. That deals with application procedures. This one deals with rulemaking, investigations, and hearings and appeals, which are not covered in Senate Bill 58. But the intent is the same.
Thank you.
Any other questions? Is there anybody else who'd like to speak on the bill? Please raise your hand. So.
So Mr. Michael Porter has his hand up.
Yep, I'm trying to get him.
I can assist if you like.
Okay, Mr. Porter, you should be able to unmute yourself.
There I am. Good afternoon. Madam Chair and distinguished committee members. So my name is Mike Porter. I'm an attorney. I'm also the administrator of OPLC enforcement. I had a long speech prepared, but I'm gonna reduce it because I know you folks have sat through a lot of testimony today. But I do want to discuss the primary functions of OPLC, which, as you all know, is to strengthen the workforce in New Hampshire through ease of access of professional licensure. Second, through the enforcement of statutes and rules governing professional licensure, our mission is to protect the health, safety, and welfare of the public, while also balancing the due process protections of professional licensees. The reason we have put this forward to you is currently we have 55 boards, commissions, or councils combined. And right now we operate under 55 different sets of statutes and rules. This has proven to be a tremendous, undertaking when trying to follow a complaint process through final adjudication. And I want to tell you that since October 2020, the senior leadership team, we've met and continue to meet with all the boards to review a more efficient and effective complaint process. As a result of these meetings, a number of boards have signed on to a new complaint process through standing orders. these standing orders do allow complaints to be centrally processed, reviewed, and submitted to the boards at an early stage, which then brings the final decision a lot sooner than in the past. And I can tell you in the past, we have had some cases range anywhere from 1 to 3 years. We feel that that does not provide for an efficient or effective complaint processing system. Number one, for those members of the public who have legitimately filed a complaint. But number two, it also doesn't benefit the licensee to maybe be currently practicing for 1, 2, or 3 years, only to have their case finally adjudicated and then some sort of administrative discipline issued. So the proposed statutory changes to the enforcement process does provide the consistency and efficiency from the filing of an initial complaint all the way to final adjudication. There are no two cases that are alike. The manner in which each case is handled should be similar. And again, as I mentioned, under the current statutory scheme, each board has a unique mechanism to process the complaints. One of the central issues that we find particularly bothersome is on the final adjudication of complaints. As I said, so in the past, when a board or commission or council issues a notice of hearing, the parties engage in settlement negotiations. Unfortunately, some of these cases may not be resolved through either settlement or final adjudication, ranging anywhere from 1 to 3 years. We are currently working on a process internally where if a board requests a matter for adjudication, we have 60 days from the date that they request that to settle the matter. And if it's not settled on day 60, we then issue the notice of hearing and the matter is scheduled to be heard within 30 days. This places the matter before the boards, commissions, and councils within what we believe is a reasonable time period, resulting in the issuance of final determinations of complaints in a timely, efficient, and effective manner. What's primary here as well is throughout all of these changes that we've made, and I need to be crystal clear, the boards are not relinquishing any rights, power, authority, or any of that nature. Every board, commission, and council has absolute final say on every case that any complaint that is filed before their board. Many of the boards and commissions and councils have, as I mentioned, been utilizing this streamlined process through standing orders. Currently, the Board of Medicine, Board of Nursing, Barbering, Cosmetology and Aesthetics, Accountancy, and many more are following this. Since we started this enforcement division in September 1st of 2020, we have processed 1,198 complaints. Of these nearly 2,000 cases, we've also handled 22 emergency suspensions for matters involving imminent danger to the public health, safety, and/or welfare. In addition to the emergency suspensions, we've handled a number of preliminary agreements not to practice. That's in lieu of a suspension pending the outcome of an investigation. All of this is an effort to protect the public health, safety, and welfare. The pros to the proposal are numerous, but most important, this process allows for the immediate protection of the public health, safety, and welfare. And by that, what I mean is all complaints come through a centralized process. We have 2 individuals that screen every single complaint. They're trained to look for items that may be an imminent danger to the public health, safety, and welfare. They then bring that directly to me. I review the matter, pull up the statutes and rules right away, and then I go to our chief prosecutor. This all happens literally within less than an hour's time. If we deem at that point that there's an emergency where we have to emergently suspend a professional license, we then raise this level to the executive director who has final say. I want to reiterate that the boards, commissions, and councils throughout this entire process have no diminished authority of the boards. There's none. They will have the ability to address matters in a timely, consistent, and efficient manner, all the while retaining jurisdiction over every case that comes before them. I just want to give you a very brief sampling of some of the cases that we've handled since September 1st, which were the result of our initial screeners through this centralized process. In December 2020, we were made aware of an individual engaged in the unlicensed practice of medicine, whereby the individual had women expose themselves while he conducted examinations. The Board of Medicine does in fact have jurisdiction over unlicensed practice of medicine. We were able to successfully prosecute that matter. We investigated the matter in less than 30 days. We adjudicated the matter before the Board of Medicine in March of this year, utilizing our investigative staff and our prosecution division. Another matter we were made aware of, I believe was October or November, was a speech language pathologist who engaged in assaultive behavior of a 3-year-old child by angrily suspending the child by his ankles inches above a school building floor and then proceeding to drag that child by the arm down a hallway. We were immediately able to suspend the license of that licensee and move forward with adjudication. During the height of COVID, we received information of a pharmacist diverting a dose of Moderna COVID-19 vaccine from a hospital. We were able to secure a preliminary agreement not to practice pending the outcome of an investigation. In October of 2020, some of you may have heard about this case. We were made aware of unsavory business practices of a for-profit post-secondary nursing school in Manchester, which caused students enrolled with financial hardship. Within 4 days of receiving the initial complaint and report, through our investigation, through our new streamlined process, we were able to immediately suspend the operation of the school to prevent further financial harm. More important, at final adjudication, the Board of Nursing revoked the for-profit school's authority to practice in New Hampshire, thereby permanently safeguarding students from further financial harm. And another one more recently involved another licensed professional who the allegation was engaged in possible sexual assault on a client of theirs. We immediately suspended the license, notified the police department, and as of last Sunday, this individual was arrested on aggravated felonious sexual assault. This is just a small sampling of matters that we've pursued aggressively, efficiently, and effectively to protect the public health, safety, and welfare, all while also ensuring that the licensees' due process protections are provided. I also want to say one last comment about this particular bill in the rule writing portion. It also brings unlicensed practice to all boards. Right now, I believe we only have a handful, maybe 5 boards total that actually have jurisdiction over unlicensed practice. I can tell you about one case that is going to be heard and involves wrongful removal of escrow funds to the tune of about $130,000 or $140,000. These cases are cases that we are immediately able to engage in. And because of the ability to go after somebody like that, we can prevent further harm. We recently settled 3 unlicensed real estate practice cases where we were able to utilize the statutory language. We could not determine the economic gain that the out-of-state realtors gained, but we were able to issue a $10,000 fine as a max fine to each individual. These are just some of the processes that are identified in the bill. And I can tell you, as someone who has been with this enforcement division since day one and helping build it, we have seen a tremendous benefit to the public health, safety, and welfare. But we've also heard from the Civil Defense Bar that they feel that their clients are being offered due process protections, which they believe is a step in the right direction. So with that, I'm submitting my testimony, and I'm happy to answer any questions.
Okay, thank you. Does anyone have questions? Representative Sytek?
Mr. Porter, are you doing anything special tomorrow morning at 10 o'clock?
Well, I am supposed to be in the Board of Nursing meeting, but I believe I can probably get somebody to fill in.
We might have some questions for you at that time. Additional questions. Detailed.
I'd be happy to join you at 10 o'clock.
Okay.
Any other?
There's one of the things I'll develop then, but I'll just tell you, this is strange here. The OPLC is going after somebody who, for aggravated felonious assault, for a quack asking women to expose themselves. Can you reach people who aren't, you're not police. How do you reach people who aren't licensed? I mean, these are criminal offenses we're talking about.
Correct. That's a great question, and I will be brief. So with the unlicensed practice of medicine, that came in as a complaint, and we investigated it to determine whether we had jurisdiction. Under the Board of Medicine statutes, the Board of Medicine, in fact, can reach unlicensed individuals. We can issue a cease and desist if found in violation of that statute. The Board of Medicine can issue up to a $50,000 fine, and it is also essentially a per se misdemeanor. In this particular matter, when we received that particular case, we did make the referral to the appropriate police department at the same time, so that we could do a parallel investigation. On the other individual with the aggravated felonious sexual assault, that came in with a potential concern of what we call unprofessional conduct under our statute. When we were able to dig into the information a little bit deeper, not only did we suspend him, but I personally contacted the Nashville Police Department that same day and made a report and handed over all the information that we had, so that we could make sure. So they're parallel investigations, but we do have the authority on several boards to reach out to unlicensed practice.
Thank you. It's done 90% of my interest. Thank you.
Sure.
Representative Schuett?
Thank you, Mr. Chair. So, Mr. Porter, is it fair to say that if someone is doing a criminal activity in addition to unlicensed practice, you could take immediate steps, whereas criminal prosecution would be a much longer process?
That is correct. And I do want to mention this. We had recently received a report of a nurse who broke the fingers of an elderly patient in a long-term care facility. We were notified the day of the arrest, but that person could make bail and potentially work in that profession again. We immediately suspended that person's license. I think we received the report at 4:09 p.m. By 5:15 p.m., that person's license was suspended, and she just entered into a preliminary agreement not to practice, which under emergency suspensions, they have the right to be heard within 10 days. But under a preliminary agreement not to practice, it extends it out so that we can conduct our complete investigation.
Thank you.
Thank you.
Representative Pearson?
Thank you, Mr. Chairman. My question involves, the bulk of what we're talking about in reference to this massive thing that the Senate has sent us. And that is with your investigative part of things and the look that you guys give to these situations, would you expect that a New Hampshire licensee that was having a problem in, say, Arizona come before your investigative team? And they would handle that, or you would handle that? And then vice versa, if we had someone from Pennsylvania practicing in New Hampshire, would you expect the investigation would be solely conducted by you? Or would this involve the jurisdiction where the primary licensee operates from?
That is a loaded question. So I'll tell you this. We will cooperate with any other licensing body. And so, for example, we had a situation with a hospital in Boston, Massachusetts, where the individual was there on a temporary license. We held the permanent license. And so they reported to us the issue. And we conducted Massachusetts is conducting their investigation, but because of the report, we're doing a simultaneous investigation. If a New Hampshire licensee engages in misconduct in another state, and we do find out about it, we absolutely have the jurisdiction under our statutes to conduct an investigation to ensure that no statutes of ours were violated. If a statute is different in another state than ours, we haven't crossed that bridge yet, but if we do, we would also probably seek guidance from our general counsel.
Follow up with that?
What's that?
Mr. Chair, can I have a follow-up?
Follow up.
Thank you. So basically, as a general rule, there's got to be one group of people that are in charge here. So has this been worked out with these compacts? Are you aware of how how this handles, when these situations come down, as far as who actually is the lead, because that needs to be defined if it isn't.
So yeah, if the violation occurs in the state of New Hampshire, we are the lead. And what happened, and I'll explain it under the Nursing Practice Act. That's the largest compact licensure, I believe, that we have. We have individuals here who might engage in unprofessional conduct. We will take the investigative lead. If we deem that conduct does rise to the level of violation, we will notify the home state as well. Because what happens is a nurse here on a multi-state compact, for example, we under the compact licensure, and I forget which section it is, I can visualize it, but we have the primary ability to investigate and hold accountable, by the way, even though it's a multi-state license. But once we've reached that adjudication stage, or even prior to, if we deem it to be emergent, we not only will report to NERCs or the National Practitioner Database, but we will actually contact the home state directly, just to make sure that there's no misinformation or there's no cross signals. Because in some cases, we've actually had some nurses who, one case in particular was kind of a catch me if you can. Well, we caught her. She was up here but lived down south. We emergently suspended her, and she essentially ignored us until I believe she had a knock on her door from her home state, suspending her abilities as well. So we haven't, being centralized the way we are right now, and it's through standing orders, really gives us that jump, that head start. And I want to be clear, these are the more severe cases. I will tell you, this is less than, I think, even 0.5% of our licensees. I would say 99% of our licensees are acting within the professional guidelines. But these are some of the worst that we do see.
Thank you.
Representative Sytek? Okay, thank you. Any other questions for Mr. Porter? I don't know if there's anyone else signed up to speak on this section. I'm not aware of one. So is there anyone who else who would like to speak on this section of SB 133? So please raise your hand. Okay, seeing none, I'm going to close the hearing on section 7 of SB 133.
And Senator Ward is here for section 8, Mr. Chairman.
Excellent. In that case, I open the hearing on section 8 and I call Senator Ward.
I just promoted her.
Okay. Can you hear me now?
Yes, thank you.
Thank you very much. Thank you, Mr. Chair, and the members of the committee. I'm taking care of part 8 of SB 133. Has to do with skilled professional medical personnel. Long-term care has to do with eligibility and service coverage authorization. Skilled professional medical personnel employed by or designated to act on behalf of the department shall determine clinical eligibility in accordance with the criteria in subparagraph 1, parentheses A. And I will go a little bit further down. The person shall train all people performing the assessment. And the most important part is that the only skilled professional medical personnel who are registered nurses and currently licensed in accordance with RSA 326-B may render an adverse clinical eligibility determination. Thank you, Mr. Chair.
Thank you, Senator. Are there any questions of the committee for Senator Ward? Don't see any. Would whoever, I know there are some other people who wish to testify in this section, so could you raise your hand, please, so we can bring you up? Douglas Osterhaus. Mute yourself when you're here.
Hello, Madam Chair. This is Douglas Osterhout. Did you just call on me? I had a technical glitch.
You were promoted to a panelist, so we can all hear you.
All right. Thank you, Madam Chair and members of the committee. My name is Douglas Osterhout, and I am with the Bureau of General Counsel for the Department of Health and Human Services. I actually have a colleague with me here today, Wendy Altman. She is the Bureau Chief for the Bureau of Elderly and Adult Services. And with your permission, I'd like to have her unmuted, just in case there are any questions that she might.
She has been brought forward as a panelist.
Thank you very much. So I'll be brief. I know time is short today, but we're here to request the removal of Part A from the bill as it pertains to those skilled professional medical personnel and limiting those permitted to render adverse clinical eligibility determinations to only registered nurses currently licensed in accordance with RSA 326B. So Senator John Reagan sponsored SB 49 in 2015 to change the language identifying who's permitted to make those determinations from registered nurse to skilled professional medical personnel. This was at the department's request, and we testified in favor of this change as it would broaden the scope of individuals under the law permitted to conduct clinical eligibility assessments and issue determinations. So for example, by allowing for APRNs to conduct assessments. And we did this so that the department could fill key positions and avoid delays in the provision of services to the citizens of New Hampshire. Prior to that change, the limiting language had at certain times placed the department in the position of being unable to fill the roles of those tasked with issuing determinations, which in turn led to delays in issuing decisions, which again in turn led to delays in services. And that's something we're trying to avoid. So the second thing I'd like to address quickly with you is that the language of proposed paragraph 3A would require skilled professional medical personnel to oversee service coverage prior authorizations for Medicaid, home, and community care waiver services. That's the CFI program here in New Hampshire, Choices for Independence. It's not necessary to meet the definition of skilled professional medical personnel in order to administer or supervise staff of a program in which staff render determinations. This language as proposed singles out the department and department staff who administer these programs. Excuse me. Sorry about that. And places restrictions on program administrators and supervisors beyond those required for similarly situated entities. So just to give you an example, there's no requirement that an administrator or supervisor of a nursing facility meet that definition. So I had a conversation with OPLC, and they confirmed that non-clinical personnel may supervise clinical personnel. It's the licensee who's responsible for their clinical decisions. Additionally, there's no specialized training included in skilled professional medical personnel training, for example, that of a registered nurse, that would provide the trainee with administrative or supervisor capabilities beyond those of administrators or supervisors who haven't undergone similar training. Additionally, the language in 3A would limit those permitted to render adverse service coverage determinations to only registered nurses, and that would require the department to devote medically trained staff to render adverse determinations for requests that might be denied for non-clinical reasons. So for example, an incomplete application or failure to exhaust third-party liability. Denials like these, they do not need the specific skill set of a registered nurse. They're programmatic or administrative in nature. And the third point I want to address today is that the language of proposed paragraph 5 defines skilled professional medical personnel as having the same meaning as in 42 CFR section 432.2, CFR being the code federal regulations, the federal rules we all have to follow. With the exception of the need for skilled professional medical personnel needing to be in an employer-employee relationship with the department. So while that employer-employee relationship is the only explicit exception to that definition found in 432.2, the requirement that only registered nurses may render adverse clinical eligibility or service coverage determination creates additional exceptions to the definition, which, by the way, includes physicians, dentists, nurses, other specialized personnel with professional education and training. And so this additional exception results in the definition of skilled professional medical personnel being more restrictive than the federal definition and places additional restrictions on who may render adverse determinations. So for example, under the current more encompassing definition, an APRN would be able to render an adverse determination. Under the proposed definition in conjunction with some other language in the bill, they would be prohibited from doing so. Additionally, and this is my final point, when SB 49 was introduced in 2015, a subcommittee of the House Health, Human Services, and Elderly Affairs Committee worked to hone in on that definition of skilled professional medical personnel and made that decision to remove the reference to 42 CFR section 432.2 under the belief that inclusion of two CFR definitions, the other being 432.50 D1 2i, would be very confusing. And they chose that definition for its reliance on the use of the term professional education and training. So again, we are asking for removal of part 9. I am available for questions both today and in any subcommittees you may need me in.
I hope you're talking about section 8 because that's what it is now.
Yeah, what was I saying?
Okay, are there questions? Representative Goley.
Thank you, Madam Chair. Madam Chair, this is more of a question to you. Will we get some input from Health and Human Services Committee on this? I think this mostly deals with their subject topic than ours.
Yes, good point. I will send a note to the chair and ask them to comment on it or support the subcommittee.
Thank you.
And Representative Schmidt.
Thank you, Madam Chair. So I have some questions because as much as Mr. Osterhout is very expert in the subject, for those of us who are not, and I include myself in that category, some of it is a little bit a forest of technical terms which are not necessarily illuminating for the unskilled practitioner, again, including myself. So you're talking about determinations, adverse determinations. So this means you're turning people down for treatment?
So thank you for your question, Representative. The CFI, Choices for Independence program, which this bill covers, that's the, I want to make sure I get the home and community-based care waiver services. So essentially Medicaid would require an individual to be in a nursing home. CFI program is a program that allows individuals to stay in their home and receive services. So yes, when I'm talking about eligibility, it would be a denial of those services under that application.
Okay, follow up.
Yes, before you ask your next question, would these adverse determinations also affect eligibility to receive Medicaid care in a nursing home?
Thank you for your question. No, I don't believe so. I believe these are limited to the 1915C Choices for Independence waiver program. Just to clarify, so everyone's on the same page, the CFI program does use the same eligibility criteria as nursing facility eligibility. That's 151E3.
Thank you. Representative Schmidt, please answer. your question.
Well, okay, so the question of the chair, is this going to the subcommittee, Madam Chair?
Why, yes, Representative Schmidt, every part of this bill is going to subcommittee.
Okay, excellent, because some of this, I think, should be explored in the subcommittee more than we can under these circumstances. But so, Mr. Osterhout, my next question is, we're not talking about as the treatment for people being rendered by people who are not at least nursing trained individuals. We're not talking about treatment. We're talking about the eligibility for treatment that's being decided on. Is that correct?
Correct, Representative. So the way it currently works is the department subcontracts with a company called KeyPro. KeyPro sends a registered nurse and uses a medical eligibility assessment tool as required by statute and does a face-to-face interview with the individual. And then if the person is found open for services, then they are immediately open. If not, that means enrolled in the program. Sorry. And if not, then it's sent to the department and we do a deeper dive by taking a look at the individual's medical records. And it's a rigorous process. You have to go through at least 3 reviews by skilled professional medical personnel, 1 being KeyPro, 2 in the department. We have 3 individuals who do that. Currently, all 3 are RNs. And you have to have all 3 of those individuals, both the KeyPro and nursing staff here, say no before you're denied from the program. But it is, to your question, strictly for eligibility purposes and not the people providing the hands-on service.
Okay, so if I understand correctly, the follow-up. So if I understand correctly, this procedure has been in effect since approximately 2015. Is it working well in the opinion of the department?
Yes, sir.
Follow-up.
Follow-up.
Is there anything unusual about this procedure in terms of how other states handle it, if it's working well?
That's information I do not have on hand, Representative.
Okay, we'll look at it in the subcommittee. Thank you.
Yes, sir.
Are there any other questions? Is there anyone else who wishes to testify on section 8? See any hands? So we will move on to part 9. That is Ms. Marling, is Senator Hennessy with us? Okay, she is being promoted.
Yes.
Senator Hennessy, you should be able to unmute yourself and speak to us.
Can you hear me now?
Yes, there you are.
Okay, thank you. I am here to introduce part 9, which is on page 48 of the bill. And it is relative to temporary licensure of certified licensed nursing assistants. And what this does is allow the recognition of the hard work of those people who completed an 8-hour training course and became temporary healthcare providers during the COVID pandemic. And these people were very critical in serving the needs of especially our nursing homes in the pandemic time. And this would allow those individuals who have done this online training and had no fewer than 100 hours of work under other licensed professionals in the healthcare field to be recognized as LNAs if they've also completed the required continuing education for LNAs.
So that, if I understand correctly, you're saying that these people can take an online course and serve for 100 hours and then be eligible for licensure as an LNA.
Yes, that's correct. And there are other people on the line that are much more knowledgeable about the entire process and how many individuals this will affect. But there are at least 1,000, there's at least 1,000 LNA shortage of workforce shortage in the state currently. And this would just make a little bit of dent in that population that we're looking to fill.
Thank you. Representative Broder, you have a question?
Thank you, Madam Chair. Senator Hennessy, this is therefore restricted to a certain group of people. It's not something that would be ongoing.
No, thank you for the question. This is not ongoing. It is restricted to those who have completed 100 hours or more by April 1st of this year.
Thank you.
Yes. Yes. Actually, Senator Hennessy, why wouldn't we want to continue this program? Since
I am
such a shortage of LNAs.
That is a great question, and I am happy to support an extension of that deadline if the committee so chooses.
Thank you. Representative Fellows, you have a question?
Thank you, Madam Chair. Senator Hennessy, I'm just curious about the 100 hours and how you came up with that amount, because that's not a lot. I mean, that's less than 3 weeks of actually doing this. It's kind of like apprenticeship, 3 hours of apprenticeship. How does that compare with the standard training program for the LNAs?
Representative, thank you for that question. I do not have the answer to that. Someone else testifying will have the answer. I'm not a healthcare professional.
So are there other questions for the senator? Seeing none.
Thank you, Madam Chair. And I apologize. I believe I forgot to introduce myself. Erin Hennessy, Senate District 1.
Thank you very much.
Thank you.
So, would whoever else wishes to testify on section 9, please raise your hand and we'll recognize you. Teresa Rosenberg.
Yes, good morning, good afternoon. I'm sorry, it is afternoon, Madam Chair and members of the committee. I'm Teresa Rosenberger. I work for the law firm of Bernstein Schuer, and I am here representing the New Hampshire Healthcare Association. And let me just give you a little bit of history about this. When COVID started, as we all remember last March, the federal government extended a waiver for states allowing temporary nurses, aides, and nursing homes with limited training. As you will remember, the federal government also put in their $600 stipend for people who chose for one reason or another not to work during COVID because of childcare issues, healthcare issues, et cetera. So once they put in that $600 stipend on top of unemployment, the nursing homes were losing a lot of staff. So this federal waiver was really a huge help. And what ended up happening is New Hampshire called these people temporary health partners, and they were authorized to work in the nursing homes under licensed staff supervision by an emergency order 42 that the governor put into effect May 11th. These workers, I have to say, provided invaluable help and assistance. They were always supervised by licensed staff, but they really helped. There for a while, we were having to even have people who were working in food service come in and help with residents. It was a bit of a mess. As Senator Hennessy said, the New Hampshire's experienced a huge shortage of licensed nursing assistants. We went from June of 2018 to June of 2000 and May of 2020 22 years, we suffered a net loss of nearly 1,300 licensed nursing assistants. And that's a tremendous loss of really valuable staff. And we also, unfortunately, have a number of licensed nursing assistants going to Massachusetts because, as you can imagine, there's a lot better pay in Massachusetts, particularly with hospitals, et cetera. So we've had a real shortage. To say that this language that Senator Hennessy has introduced is going to solve the problem, no, but it is a real help at a time we still very much need workers in the nursing homes. It's a step forward. These are men and women who've shown interest in healthcare and in nursing, being nursing assistants, and they've really been an integral part of the system for the last almost year plus. So we appreciate the bipartisan support. We appreciate Senator Hennessy doing this, and we just really would ask you if you could move this forward because we very much need the help. And I'm happy to answer any questions that I can. Thank you.
Representative Grota, you have a question?
I do. Thank you, Madam Chair. This is not the first time, Ms. Rosenberger, that we've heard about people leaving the state because we don't have adequate pay.
Right.
And therefore, can we do something about our standards so that people who don't meet them but are willing to take the pay get the work? How would you feel about amending this so that we bring the people that are working at this special level to eventually meet the criteria that we have for the state?
I'm not quite sure I understand the question, but let me respond, and then I'd love it if you'd ask me again.
Yeah.
The way this has worked, and we did work with the Nurses Association with it. When this started, I will say, Representative Brody, back in last March, lots of conversation and collaboration with the Nursing Association, OPLC, the organizations that train the nurses and the licensed nursing assistants. And so the program we came up with for the temporary licensed nursing assistants was really worked in collaboration with all of them. If you see in the bill, there's criteria in there that you have to have so many hours of training, that you have to work so many hours as a temporary health partner, that you had to be doing this by a certain date, and that also the important part of it is one of the things the Nurses Association wanted is that you're required to do continuing education. So we've tried to make this as, I guess I would say, as finite as possible and make sure that these men and women are supervised by licensed nurses, but we are giving them credit, frankly, for the work they are doing while they have been in this temporary position during COVID. So they've gotten some valuable experience, I will say, probably more so than they would have without COVID, because the staffing has been such, and they've really, it's been an all hands on deck situation. So I don't know if that answered your question. It was an attempt.
It was a very good attempt. And, thank you. I do have a follow-up question though.
Follow-up.
Thank you. I'm commenting, I'm responding to the comment that was made, the question that was asked previously. Should we make this a standard operating procedure?
Well, I will speak, I will ask my client, but I will speak with great knowledge of my client and their constituents, meaning the nursing homes. I would say yes. The shortage of staff has just been unbelievable. We have administrators. I was on the phone this morning with an administrator who said, she's now having to roll up her sleeves and go in to give care. She stated, and this administrator is in the North Country, this nursing home administrator, and she said they have contracts with 10 staffing agencies looking for staff to help. And as you can well imagine, if you're having to go through a staffing agency to get help, you're paying top dollar because you've got people coming in from out of state helping, and the costs are they're high. But she said, we not even being able to get people from the staffing agencies to come in the North Country, and here she is, the administrator, is going to start giving direct care. So I think anything the state can do to help this situation would be terrific. This is a small step. There are other things, obviously, we would love to advocate, not so much so in this bill, but it's a help. I was on the call every Friday during the pandemic, and now it's every other week with these folks who are running the nursing homes, and they are doing God's work. It was amazing what they were doing, what was going on, and what the lack of staff was really, the problems it was creating. The temporary licensed nursing assistants was a huge help at a really crisis time. So long-winded way of saying yes, I think if you would like to do it for the long term, that would be great. We'll take any help we can get.
So I have a last question, Madam Chair.
Yes, Representative Baroda.
Thank you. If we were to do this, then how would this work without losing the quality care?
May I ask what you mean by quality care?
Well, let's just say that we have standards now that are met based on what we think provides quality care to the resident, right?
Right.
So if we were to, I'm going to just use the expression lower the bar.
Yes.
Okay. Right. And then how do we know that when we lower the bar doesn't stay low?
Right.
And so what would be the gradual, could there be a program implemented so that, okay, the bar starts low, but then there is a step-up curve to meet the current standard?
Let me get back to you on that, but I will say that I think in all the conversations from when this first started, the thought was you had people who were out of work who might, and particularly in the food service industry, et cetera, who might be looking for change in professions. So if we could get them in, give them a try, see if they liked it, and then they could go through the process of actually becoming LNAs. And so I think everybody's thought initially was, one, this was help, but it was also getting people into the system to see if they were cut out for the work. And then through that, let them get hands-on experience as well as go through some education and eventually become a licensed nursing assistant.
Thank you so much. And thank you, Madam
You're welcome.
Chair.
And I will get back to you. I'll send you some written information on that as well.
All right, thank you.
The idea is this is a gateway, frankly, to getting people into the system that are licensed LNAs.
Thank you.
Thank you.
Thank you, Madam Chair, and thank you for taking my question. I don't know if you have the answer right now or if you could get it for us. Do you know what the average entry wage is of an LNA that nursing homes are paying?
I don't, but I can give you a good guess, but I don't. But I do know that one of the issues, frankly, has been, Representative Goley, that and it's not just nursing homes who have limited staff, it's hospitals as well. And hospitals are much more well capitalized than nursing homes. So unfortunately, well, in fact, on the call this morning, there was a woman who said they had 3 people who came in and they were trained in an LNA program in their facility. they worked, and the hope was, again, this was an entry level into these people being there. One of them left and went to Massachusetts, and the other one went right down the street to the local hospital because they can pay more. And I think the hospitals maybe are paying $17.50 or so an hour, and probably the nursing homes starting are around 12. As you know, I could get really complicated into this, but it's not the ED&A committee. Part of the real issue here, Representative Gully, is the Medicaid reimbursement rates. And with Medicaid reimbursement rates not what they should be, the nursing homes have they can't pay what a hospital can pay, because the rates are way too low. And frankly, it would be great if the finance committee would somehow or another raise those Medicaid reimbursement rates. We could certainly pay more.
So follow up?
Yes.
So qualifications may not be the complete issue. Wages may be another factor in this, correct?
Wages, is absolutely no question. Wages are a big issue. And what you've got right now in the nursing homes is because when COVID hit, you couldn't take patients who were tested positive for COVID. And so all of a sudden, the census coming from the hospitals was less, because you get a number of people referred to nursing homes that are coming from hospitals that need rehab. So your census was less. People weren't coming in for one reason or another. So right now you've got a decreased number of people in the home. If I could find my notes from this morning, I'll tell you, this is just what we were told by this nursing home in the North Country this morning. Costs are up 58%. Wages are up 34%, and that's because they're having to get staff from staffing agencies out of state. The occupancy rate is down, and the revenue is down 27%. And that's, wages is absolutely a problem. But this bill is not solving that problem. We're hoping other committees in the Senate and the House will help with that. But this would just really help get some bodies in those spaces, particularly of people who want to consider a career and be trained and paid while they're being trained.
Thank you.
You're welcome.
Representative Fellows.
Thank you, Madam Chair. I'm wondering if you can help me with this. I'm concerned that if the requirement is only a 100 hours on the job, that some of these temporary LNAs worked in one facility doing one task, and that they're not qualified for all the tasks that one would expect of an LNA that went through the regular program. Can you address that?
Well, I think these are temporary. They're temporary licensed nursing assistants. They're not permanent. So they are coming in on a temporary basis. If they want to be an LNA, they need to go through a regular LNA. They need to go through an LNA program, which the way this is set up, they have to have done this by April 1st of 2021. So unless you have been in a nursing home as a temporary health partner by April 1st of 2021, you don't qualify.
And Representative Fellows, you should be aware that the LNA is the lowest level of licensed health professionals.
Right.
And the education requirements are not that strict for initial licensure, but the continuing education requirements are fairly robust. So learning on the job is not uncommon.
So I still would, is there somebody else that's going to come up that can answer the questions about like what the skills are that they're expected to have? Under the regular license method?
I can get that to you if you'd like. You want to know the skills of the license, the LNAs.
Correct.
Okay.
And if you could get the normal hours of training,
yeah,
right,
that would be useful because all I remember from the study committee was that at least a couple of high schools in the state have part-time training programs that qualify people for an LNA license.
Right.
Essentially before they even graduate. Although you can't get it until you graduate, I think.
That's right. I will get you the skill level, and I'll get your comparison, Representative Fellows.
Thank you, Ms. Rosenberger.
You're welcome.
Are there any other questions? Seeing none. Is there anyone else who wishes to testify on part 9? So please raise your hand. No, don't see any. So we'll close the hearing on part 9 and go on to part 10. Let me see, the senator for part 10 is
Senator Prentice has her hand up.
excellent, thank you.
Okay, I'll open the hearing on part 10 of Senate Bill 133. We have promoted. Great. Senator Prentice, you should be able to unmute yourself.
Thank you very much. Good afternoon, Chairman McGuire and members of House Executive Departments and Administration. My name is Sue Prentice. I'm the state senator from District 5. I am a paramedic, and I'm also the former chief of emergency medical services in the state of New Hampshire. So it's fitting that I would be bringing this section of Senate Bill 133 to you, which is part 10. This is relative, I'm introducing the section that's relative to the revocation of licensure for licensed emergency medical service units and emergency medical service vehicles, as well as personnel. So there are two things that this piece of legislation wishes to accomplish. One is to align our suspension and revocation process for personnel in particular with the other healthcare professions, which I'll review with you in terms of nursing and physicians. And the second is, as part of this, promoting just culture in the performance improvement. Again, for emergency medical services professionals, licensed professionals in New Hampshire, like our other healthcare profession partners. So back on November 19th of 2020, the State EMS Medical Control Board voted unanimously to support a change in the language to New Hampshire RSA 153A13, requiring revocation of licensure from the commissioner, saying that the commissioner shall deny an application for issuance or renewal of a license or suspend or revoke a license when the commissioner finds that the applicant is guilty of any of the following acts and offenses. And it lists out those, but the key word in here is that the commissioner shall deny. And then again, it provides a list. And so this language does not align with the other medical professions within the state. So if we look at physicians and surgeons under chapter 329.17, chapter 320 for the nurses, it would be 326B of the Nurse Practice Act. We've got B37, chapter 328D for physicians assistants. There's also for dentists and dentistry, section 317A17. They don't have shall, they use may, allowing for discretion and also promoting the ability to use just culture, which again is so this is something, when we talk about just culture, this means that an act or an offense, which could be, is minor and does not, at the discretion of the commissioner, require suspension or licensure, but has been elevated to the commissioner's level, he could, instead of denying, he or she denying or suspending a license, they could put a letter of concern in the file which is part of Just Culture, which says this mistake was made. This is how it has been remedied, and here it exists in this person's file. This is, again, a practice that is found throughout healthcare, and it promotes more openness, more transparency, and more opportunities for learning. So with that, again, I'll stop and just ask that you consider changing the language from shall to may in 153A13. Give the commissioner the discretion to issue letters of concern as a part of Just Culture. And this does not change the commissioner's ability to suspend or to revoke, but it puts another key tool in the toolbox for licensed professionals and emergency medical services, and puts it on the record should there be an issue that needs to be addressed. Thank you.
Thank you. Any questions for Senator Prentice? Seeing
Yes, he does better.
Representative Schuett.
Thank you, Mr. Chair. Good afternoon, Senator Prentice. I'm curious, when you were the head of emergency medical services, I understood that that was your position at one time. Did you encounter any instances where this would have been a tool that you would have used?
Yes, I did encounter instances where it was a tool that we could have used. A good example. So I haven't been in that position since 2010. So I'm going to use my memory here would be, you would be, normally local medical directors work with local EMS professionals. They know them the best. And so let's say there were 2 medications that could be used for a certain problem. One was used, it wasn't the best choice. It didn't hurt the patient, but there would have been a better choice. A local medical director would normally handle that. But if for some reason somebody decided to write a complaint that came to the commissioner's office or to the Bureau of EMS and ultimately to the commissioner, then their only opportunity to act on this would be to deny, would be to suspend or revoke. And that doesn't promote good patient, it doesn't promote safety, it doesn't promote transparency. And it really is limiting, where if this were to happen in an organization and happen locally, it would be handled, it would be documented, and we would all be better for that. So that would be the kind of example that we had come before us, that we were limited on how to manage.
Thank you. I think that gives us a better handle on what we're talking about here.
Yeah, thank you.
Representative Fellows.
Thank you, Mr. Chair. Mike, I have 2 questions. One of them, the letter of concern, is that something that goes in their file, or what happens with that letter? And then I have a follow-up question too.
Absolutely. So Madam Chair, if it's okay, I'll take both.
Proceed.
Proceed or sorry, who's ever. So the licensed professional would get a copy, and then it would also be part of the record in the Bureau of Emergency Medical Services.
Okay. And my follow-up question is, if you change the shall to may, that opens up the possibility that a person who is guilty of any of the following acts or offenses, that the action taken is nothing at all, because the may means you don't have to do any of these. Is that your intent?
No, it's not our intent, but it's our intent to give flexibility to the commissioner to make the decision whether they'll take one of these 3 actions instead of nothing at all, or only have 2. It's never been my experience, and I have been out of this position for a while, that when there was an issue that needed to be dealt with, that it wasn't handled appropriately. So they can still suspend or revoke, and they would be in I can't imagine a position or a situation where if they were guilty, or what is called founded in the licensure process, that they wouldn't take one of those actions.
Oh,
I'm not a commissioner, I can't speak for them, but that's what I would do.
So just follow up.
Follow up.
So the way I read it is that if that word shall stays there, you will get exactly what you just explained. putting the word may in there gives them the option to do none of those things. Do you see that, or?
I understand what you're saying, but I don't necessarily agree. The intent is not to wipe the slate clean. It is to provide discretion. And in the very beginning, Representative Fells, if I may, I mentioned that, or I stated that nursing, physicians, other healthcare professions, their boards, not the commissioners, but they have boards of oversight that do this same kind of work. They have that same language. They're given that same discretion. And so if they're providing patient care, and so is emergency medical services, again, I can't see how this would be handled any differently.
Okay, thank you.
You are so welcome.
Any other questions for Senator Prentice? Seeing none, is there anyone else who'd like to speak on this bill, the section of this bill? Okay. Director Romanello,
Oh, hi, Justin.
you should be able to unmute yourself.
Good afternoon. Thank you, sir. Again, my name is Justin Romanello. I'm the chief of the Bureau of EMS for the state of New Hampshire. And I don't want to echo everything that Senator Prentice said, but the tool here is to give the commissioner a few options. What we've done in the past, or what he has done in the past, is in a case where we intend for the letter of concern to be used, what we've done is he's either revoked the license or suspended a license in abeyance. And so it's still on the individual's record, but they wouldn't actually have an action taken directly on their license unless they've committed a follow-up action in a time period that was determined. So where I see this being utilized would be in cases that we may have done that in the past, and I apologize, I don't have an example for you, but where an action may not have been justified to take against the license, where a letter of concern would have been more appropriate for that individual, but the only option that the commissioner had at the time was to take the action against the license. As Senator Prentice did say, we're not trying to give the commissioner the flexibility to not act, just to act more appropriately, and provide those options for him or her. Also, as Senator Prentice mentioned, what we also are trying to do is create that just culture. I think what keeps me up more at night is the stuff we don't hear about, and the stuff that people are afraid to give us as far as complaints, for us to perform an investigation, because of the only options that are had are in fact a revocation or a suspension. So I think by changing the word into may from shall and adding the letter of concern as a tool, this will put us more in line with the other healthcare professions that Senator Prentice mentioned, and thus creating that same just culture that we see in those industries. I appreciate the time and can certainly answer any questions if anybody has any.
Are there any questions? Seeing none, is there anyone else who'd like to speak on Section 10 of SB 133? Seeing none, I'm going to close the hearing on this section of the bill.
Thank you.
Next.
And Senator Reagan is the prime sponsor for the next couple of sections. I have left a phone message and emailed, but I have not heard from him.
Okay, thank you. Let's see who else is sponsored. All right, I'll open the hearing on Section 11 of SB 133 and recognize Representative McGuire to speak on it.
Thank you. I'm Carol McGuire, representing Merrimack District 29, which is the towns of Allenstown, Epsom, and Pittsfield. And Part 11 is a change to the definition of a school for barbering cosmetology by allowing a dedicated program to be counted as a school. And doesn't have to be a completely independent program. For example, you could have a dedicated program within a high school. And I believe that's one of the places where they're interested in it. It also requires a apprentice in such a program to register with the board and gets an apprentice certificate, which is identification, shows their age, and that they're of good professional character, which is easier. And so it allows apprentices to start and to work as apprenticeships in the program. And the board retains the authority to set the rules. And once they complete those hours, they can apply for license. That's all I can say about this.
Any questions? If so, please raise your hand. Okay, seeing none, does anyone else wish to speak on section 11 of SB? Okay, Representative Goley.
Thank you, Mr. Chair. Just a quick question, as we had a bill dealing with this subject in committee prior that is on its way to the Senate. The languages do not mirror each other. What will happen if both pass?
That's an excellent question, and I think it will be an issue. The part about the school or a section of a school, a program within a school, is unique to the license, to this bill, and it wouldn't be affected either way. The rest of it, you have identified an issue that needs to be solved.
Thank you.
Mr. Broderick, you had your hand up. Would you like to speak? You should be able to unmute yourself.
Great, thank you very much, and good afternoon, Chairman and members of the committee. So for the record, I'm Tom Broderick, legal counsel at the Office of Professional Licensure and Certification, or OPLC. And as you know, the OPLC provides administrative and clerical support for the 54 occupational licensing boards, commissions, and councils under our umbrella. So I'm here now to speak on section 11 of SB 133. It begins on the bottom of page 49 and ends on the page 50. This bill affects the Board of Barbering, Cosmetology, and Aesthetics, but I want to make clear, right now I'm speaking on behalf of the board, of the OPLC, the agency, not the board. I've consulted with the board on this process. They're aware of this, but I'm speaking for the agency. So OPLC we requested this change after consultation with the board, really to fix and or to clarify two issues with the board's Practice Act. Both issues concerns the board's authority to regulate programs within high schools. So the board actually currently licenses independent schools, such as Tom Broderick School of Barbering, but it also licenses a few programs within high schools. So for instance, Concord High School has a cosmetology program where students get an apprentice license from the board and learn cosmetology at the high school. The first issue that this legislation is seeking to resolve is clarification as to whether the board has the authority to license and regulate programs within high schools rather than just independent schools. As I mentioned earlier, the board currently does so and has for a long time. The confusion comes from a discrepancy between the definition of school in RSA 313A112, which is broad and reads, just school means a school or other institution conducted for the purpose of teaching cosmetology, manicuring, barbering, or aesthetics, versus RSA 313A72, which reads, the board may license a school to operate post-secondary programs, including post-secondary programs leading to a certificate in barbering, cosmetology, and aesthetics. So we have one statute that says the board may license schools, and schools are broad, and then another statute that says they may license schools to operate post-secondary programs. And so in this bill, page 49, lines 21 through 33 are really seeking to resolve this ambiguity and make clear that the board may continue to license and regulate the programs within the high schools. The second issue that this legislation is seeking to resolve is a little bit more complicated. So under the Child Protection Statute 161B11 6A, OPLC and really any other state agency is required to collect the social security number of any applicant for a professional license. But for these students, specifically the students within high schools, within public high schools, under, I believe it's FERPA, the school cannot require a student to provide their social security number. So we have a bit of a catch-22 where the school cannot request a social security number, but the board must require it if we're saying these students need to have an apprentice license with the board or apprentice certificate with the board. So the remainder of this bill, which is page 49, lines 34 to page 50, lines 23, is meant to fix this issue. So in short, that section is meant to exempt those applying for these apprentice certificates from the requirement to provide a social security number. That concludes my public testimony. The one thing I'll add is, Representative Goley, I was unable to hear your question because I was being promoted to panelist. So if there's something I can answer, I'm happy to do my best to.
Okay, thank you. Any questions? Representative Goley.
Yes, I just want to repeat my statement, or my question was that if this and the bill that was currently before the House committee that's off into the Senate dealing with the subject matter both passed, that there will be an issue.
All right, I'm not clear on which bill that is, but I'm happy to look into
I
it.
believe it's House Bill 575.
All right, I'm happy to look into that and get back to the committee.
Okay, thank you. Any other questions? Representative Fellows.
Thank you. Can you tell me, does OPLC or the board of barbering and cosmetology, do they approve the schools and the programs that are in schools?
Yes, the board, not OPLC, the board approves schools and has curriculum requirements set via rules.
Okay, so thank you. So my follow-up?
Follow-up.
So my other question is, how does this work with approvals made by the Department of Education of vocational programs? How do those two things work together?
I would have to get back to you on that. I know I've looked into that a little bit for the electricians who have some voc programs and also the board. I haven't specifically looked at that for the barbering and cosmetology.
And I have one more follow-up question.
Follow-up.
Yeah, right now, do the students who graduate from those high school vocational programs, how do they go about getting their apprentice license? Do they just get it automatically because they completed the program, or what?
I believe they get their apprentice license when they're in the program, and that's actually leading to one of the issues is to get their apprentice license, they are supposed to give us their social security number, but the school cannot ask for their social security number as under FERPA.
Any
So
further?
do they get those licenses? Are you giving them those licenses right now?
I believe we are. I need to double check with the administrator, but I believe we are.
Okay, thank you.
Any further questions? I don't see any. Does anyone else want to speak on this section of SB 133? Okay, seeing none, I'm going to close the hearing on this section.
All right, part 12. Again, that's Senator Reagan, and have you managed to get hold of Ms. Marley?
No, I have not heard from him.
See if any of the co-sponsors. Senator Carson, is Senator Prentice still here, or Senator Hennessy?
No, we have no senators left.
Right. In that case, Representative Allegro, would you introduce this?
What's that?
Don't take
Just
any
give me a
questions.
moment to get organized, please. Okay, I don't believe I need to say more than this is part 12 of SB 133 relative to telemedicine provided by out-of-state psychologists. Am I clear on that? Thank you.
I call Dr. Debbie Warner. You should be able to unmute yourself and start talking to us. Dr. Warner? Dr. Warner, do you unmute yourself and talk to us?
See her.
See her, yeah, see her. Well, is there anyone else who wishes to testify on part 12? Yes, Mr. Broderick.
Good afternoon again, members of the committee. And maybe I know Dr. Warner wants to testify as well, so maybe this will give her time to unmute. But again, for the record, I'm Tom Broderick, legal counsel of OPLC. I'm speaking now on behalf of the OPLC, not the Board of Psychologists. I believe Dr. Warner is here to speak from that perspective. I wanted to testify today to put forward that OPLC, we're really neutral on this piece of legislation. The reason I'm here is to provide an explanation of the bill and its effect on the administration of the board, which is the administration of the board is OPLC's charge. So this piece of legislation creates a new license category, a New Hampshire telepass, the intention of which is to allow out-of-state psychologists an easier way to provide psychologist services via remote technology in New Hampshire. As of now, there's currently two ways that individuals from another state can provide telepsychology services in New Hampshire. First, they can go through the regular licensure process to get licensed here in New Hampshire. That is a lengthier process. Or two, New Hampshire has joined the Interstate Compact, SIPACT. I know we've heard a lot about compacts today. So if their home state is also a member of SIPACT, they can obtain the Interstate Compact license and come here and practice in New Hampshire, which includes telepractice. So this would really create a third avenue. The main effect on OPLC's administration of the boards are as follows. So first, as I mentioned earlier, it creates an entirely new licensure category. It is an increased administrative burden as it involves granting a new set of initial licenses, renewals, drafting new rules for this process. OPLC is not necessarily against the bill for this reason, and we of course will implement it if the bill is passed. We wanted to make this committee aware though. Second, OPLC's second effect dovetails with this. So the board joined the Interstate Compact in September 2019, less than 2 years ago. Last I checked, 14 states joined. It might be 16 and are active in the compact. I think one more has joined, but the legislation isn't yet effective, and 13 more states are pending legislation this year. So that's 28 states. From what we've seen with other compacts, the number of states that joined once a compact meets that threshold, that initial threshold to become active, will only increase. So for licensees coming from these compact states, the bill is largely unnecessary and redundant, and may actually be more confusing to individuals. I do understand that this telehealth would likely have a lower fee than the compact fee, but it isn't redundant for those from non-compact states. And just lastly, I know my executive director, Lindsay Courtney, has spoken to Dr. Warner, and she may be testifying. And again, I want to make clear we're neutral on this bill, but we did want the committee to know those two pieces. So this concludes my testimony. Happy to take any questions.
Representative Schultz.
Thank you. And thank you for taking my question. So I think I understand what you're saying. Obviously, one part is your OPLC is not taking a formal stand on this, but this telepass, it sounds like something that might be too specific. Is that fair to say? It seems like by naming it and calling it out as telepass, and I assume it's not in any RSAs at this point, that type of licensing process, it sounds like it's something that's temporary, or I don't know what the word would be, but maybe just too specific. Does that make sense? My question makes sense?
So I think Dr. Warner can probably testify to this with more eloquence than I can probably, but my understanding, it's not temporary, but it is intended to allow people to, if you're a psychologist in Massachusetts and your patient comes up to New Hampshire and they need to do a session with you online, you could use, rather than getting a full New Hampshire license or going through this compact, I'm not sure if Massachusetts is a member of the compact, they could more easily get this telepass license.
And follow up, Madam Chair?
Follow up.
And it's my understanding that the executive order that allows for various healthcare to occur via telemedicine already covers this, at least temporarily?
I believe it does, but the emergency order, that would only be valid during the pendency of the pandemic. So I believe it largely does.
Thank you.
Other questions for Mr. Broderick? In that case, Dr. Warner.
Yes, thank you so much. I am sorry I had a technical issue just as you allowed my computer to get on. So I do have comments on this.
Introduce yourself first.
Can you hear me all right?
We can hear you just fine. Please introduce yourself first before going into your testimony.
Yes, thank you so much. I'm a little flustered because my whole computer just went funny, and I'm on my iPad now. I'm Dr. Debbie Warner. I'm in Littleton, New Hampshire. I serve on the board of psychologists. I'm the vice chair, and I come here representing the board. We did author this section of the bill, the part Roman 12, And we felt we had very good reason for that. We appreciate Senator Reagan bringing this forward for us. And just as he did previously, bring forth SIPAC on our behalf. We are doing SIPAC. And as for compacts, it is good to get in on the ground floor if we can send a rule nerd into the midst. I happen to be that little rule nerd, as you are well aware. And so SIPAC is progressing and they are developing good rules. We do have a little gap between what we're doing very well. We like these emergency licenses, actually. They make it very easy for somebody to very quickly come in and follow their patients into New Hampshire, whether or not they are students who've come home from school or visitors or snowbirds, or maybe visiting family who have come to New Hampshire to deal with a family crisis, perhaps, and they want to retain continuity with their care back home. Those are all very, very good uses for this little telepass license, which is basically almost the same format as our emergency licenses that are happening during COVID, which we like. We were appreciative of how that went so swiftly. Now, SIPAC itself is a big deal. It takes about 3 or 4 months to get your credentials through SIPAC, and it costs $440. And that's fine. You're going to get a lot of states in that. Currently, there are 16 states in our SIPAC compact, and so that leaves 34 states that are not. And this little telepass would take care of that, and that people who just want a little mini license and come in, it is unlimited for the year in terms of the way we see it, in terms of time and number of sessions, but it is just telemedicine, and it is meant for reaching into the state by licensed doctors of psychology. Now, there are some questions that I heard previously of how do you know about compliance and what quality of folks you're getting. We are making sure that it is at the doctoral level, and that they come in and they have to attest that they have a clean license and no issues on their license and no discipline, and that we can do this very quickly administratively. And OPLC is getting quite dandy at the online licensing and renewals and things. And so we're hoping that it would be instantaneous, that if somebody you're following goes into the state, that you can take care of them for a low price. It's not very difficult to evaluate these. And if somebody happens to lie and say that they have a clean license, but they don't, they will be in such super trouble that it is really not worth lying. When we check it the next business day or two and find out if they're wrong, they're going to get a very severe penalty in their home state for probably a revocation. We would put in our rules that we would have to construct that you would be revoked if you lied on your application like that. We are hoping that this is easy to administer, as we haven't heard any complaints from OPLC about their administrating the emergency licenses. And so we think it will be very dandy in that way. We also looking for a low price, very quick and very helpful. This will only benefit the citizens of New Hampshire and the visitors who come here. It doesn't benefit the psychologists who are licensed in New Hampshire, because actually it's going to increase the pool of talent available to draw upon. But we do have a number of specialties that we're a little sparse at. And so it would be very nice to be able to draw on those from other states. And people could, it might just be one of those New Hampshire advantages that we get to have a broader spectrum of providers be able to help us here in New Hampshire. So if you were going to, for example, get a specialty care out of New York or Boston or wherever it might be, and you can entice them to pay that extra, perhaps $100, and come and help you here with very little difficulty on their part, I think that we would find that it's very, very helpful to our people. I've talked with the board administrators from some of the neighboring states, and they want to see how this goes. if we take it on, maybe they will too, and bring that forward, and we can have just sort of a nice neighborhood of reciprocal care. We don't have any other real reciprocity with other states at this point in time. Now, I can speak on this bill with the authority of the Board of Psychologists. I am also, as I indicated, I am the commissioner from New Hampshire for SIPACT, and I can answer questions about SIPACT, but I'm not their spokesperson per se. I can just talk as your commissioner and give you feedback. Those are my points, and be happy to take questions. Thank you.
Thank you. We will be having a subcommittee on this next Thursday, and we're delighted if you could call in. And
I'm sorry, did you say next Thursday there's
Yes.
the committee?
yes, subcommittee.
I will. That's a little tough for me, but what time would that be?
Afternoon, I imagine.
Okay. If I could get that information early, that would be very helpful. I'll put that, make sure that I can do that.
Okay, the subcommittee chair will let you know when he plans to take it up. Representative Schultz, you have a question?
Yes, thank you, Madam Chair. And thank you for taking my question, Dr. Warner. I'm a little bit confused about, at one point you said the cost for SIPACT was around, I believe you said $440. But towards the end of your testimony, you said that there was, or you alluded to it in multiple parts of your testimony, but I'm a little confused. Something that is smaller than that, like a short-term or specific by client type of SIPACT
Yes.
thing?
Yes, I should clarify. SIPACT is different than this bill. This bill is to bring forward our very own New Hampshire brand of TelePass license, which is only for telemedicine. It's only for licensed psychologists at the doctoral level from other states. And we take the money and we process it. And one thing we do like about this is that they follow our rules, our laws, and they're administered by our board. We don't have to go through that other structure, which is the SIPACT Commission and all of that business at the national association level. So this fills in that gap that takes, so that we can have access that's quick and proper, and that we have jurisdiction, good jurisdiction over their practice. But in terms of the provider would like it probably because we will have a low price on this simple license, as opposed to paying $440 to SIPACT, and you get 16 states for that. But if your patient didn't go to that state, what do you do? So we're trying to fill a little niche there. It's not in competition with SIPACT, but it's just a niche in between.
And Madam Chair, I have a follow-up.
Follow-up.
So you mentioned too that there were conditions that the available practitioners are low in number, or in some cases maybe not in existence. Would you believe that I have one of those conditions, and during the executive order that allowed for telemedicine, I was able to reconnect with my therapist from 13 years ago and finally get the care I needed?
So this would benefit you, that your therapist could pay their small fee, whatever OPLC will set, perhaps $100, and be able to continue on with your care.
Thank you.
Thank you. Dr. Warner,
Yes.
which of our adjoining or New England states are in SIPACT?
We don't have any neighbors in SIPACT.
Thank you.
Our closest neighbor, I think, is Delaware. I think Pennsylvania's on its way in.
Thank you. That's what I thought. Are there any other questions for Dr. Warner? Okay, seeing none, thank you very much for your testimony.
Thank you very much for having me.
And is there anyone else who wishes to speak on part 12? Raise your hand if you do. Any? All right, in that case, I will close the hearing on part 12 and open the hearing on part 13. And last, and I believe that's Senator Gaidas. Is he with us, Ms. Marlin?
He is, and I just promoted him, so there he is.
Okay, Senator Gaida.
Good afternoon, members of the committee. I am very obviously not Senator Gaida. I am Griffin Robers, his legislative aide. I just texted him. He is coming out of a meeting and he should be here within the next 2 minutes. So if you'll just bear with me, I'll get him right in front of you guys in just a few moments.
That would be impressive. While we're waiting for Senator Gaida, I'll just remind people that tomorrow, the Representative SciTech Subcommittee will be meeting in the morning on Section 7, which is the Rule Writing Authority of OPLC. And in the afternoon, Representative Roy's subcommittee will be meeting on Sections 2 and 5, which are about the compacts.
A question of the chair.
Yes, sir.
So I'm not appointed to any of the subcommittees, but I take it that we are all allowed to sit in, so to speak, even though we wouldn't be allowed to vote.
Yes.
And-
All
and
members
we-
of the committee are welcome to attend the subcommittee and will be able to participate but not vote, as Representative Schmidt said. Right, and there's
Yes.
Senator Gaida.
Well, I didn't actually say participate. I said sit in, but thank you for that. I was about to follow up with that question. Participate is what it's at. Thank you.
Senator Gaida. Good afternoon.
Thank you, Madam Chair, members of the committee. For the record, Bob Gaida, Senate District 2, and prime sponsor of Part 13 of Senate Bill 133 FN as amended by the Senate. This bill grew out of a rule passed by the Food Services Division of Public Health, well-intended, by adopting a federal standard that would require a certified food protection manager to be on scene during working hours for any food facility at all in the state. Obviously, in the interest of safety, I can understand and respect that. Been a very low incidence of food poisoning incidents as demonstrated by their own data. But the concern here is that there are a number of small food establishments and that the $300 fee for becoming certified by a private agency recognized by the state becomes onerous when one considers the turnover in employees, which is high in the food service industry, and thereby bringing very significant additional costs as a requirement to even open your doors. And so what this bill does, it exempts small establishments. The restaurant and hotel organization is supporting this. HHS worked with us to develop this. It still makes the establishments responsible, makes them have a person in charge that's a certified food safety manager. Still has the responsibilities and obligation, exempts certain types of food preparation, such as reheating, and at the same time mitigates the significant expense with the high turnover of $300 per certification employees that is under the rulemaking that, to their credit, they have not vigorously enforced due to the pandemic and also due to their understanding of the fact that this is onerous on the small businesses. I'm happy to address section by section, but it's pretty clear. There is currently only one section, that's A11 under 143. This would add A11A, a certified food protection manager section. And with that, Madam Chair, I will take any questions.
Thank you, Senator. Are there questions? Representative Sitek.
Senator Gaida, you said reheating is exempted.
I'm sorry, I can't hear you, sir.
I'm sorry. Reheating is exempted. Does that mean McDonald's is off the hook on this?
Let me read the exact language, if that's okay.
Well, let me tell you
It's
where I'm
line
going.
14.
Let me tell you where I'm going. Does this mean if I go today into the Common Man or McDonald's, if it's not reheating, they have a certified food protection manager, somebody certified standing there? While
That's correct. They either do or will shortly be required to. I think that's more up to the call of HHS. As I said, they've been lenient in the application of this, understanding the pandemic and the slam that small businesses, especially small eating establishments, have taken. But this will be a requirement that the larger establishments that have 5 or 10 cook staff and then 20 or 30 wait staff won't have a problem with this. But the smaller establishments with fewer people, with a high turnover rate, it becomes a significant cost to them. And that's the reason for this legislation.
If you say so, okay.
Representative Schmidt.
Thank you, Madam Chair. Good afternoon, Senator. So you said such as reheating. Do you list all of the exempt activities?
Well, if you read the bill, sir, you'll find that they're in there. Okay. And I'm happy to do that. Having at least, the requirement shall not apply under these conditions. 1, food establishments having at least one certified food protection manager on staff shall not be required to have the certified food protection manager present when no food preparation is taking place.
Thank you, Senator. We appreciate your offer, but I think Representative Schmidt can read the bill. He's shown his literacy on many previous occasions.
Thank you, Madam Chair.
Does that equate to a gold star, Madam Chair?
You betcha.
Thank you, Senator.
Certainly, Peter. Thank you.
Are there any other questions for Senator Gaida? I don't see any, so thank you again.
Thank you, Madam Chair, members of the committee. I do appreciate your consideration and hope we can look for an ought to pass with this. Have a good afternoon.
Is there anyone else who wishes to testify on section 13? Yes, there are 2 people. Oh. So Mike Sillen. Mr. Sillen, you can unmute yourself and speak to us.
Well, good afternoon, everyone. My name is Mike Sillen from Aroma Joe's Coffee. I would like to thank both Madam and Mr. Co-chairs for their time this afternoon and the entire committee. And thank you, Senator Gaida, for listening to us early on last year and adding this legislative to this bill. We are in complete support of SB 133, Part 13. And I'd like everyone to understand, I'm one of the original founders. There was 4 cousins from Southern Maine that created the Aroma Joe's brand back in 2000. I currently own and operate 19 stores locally with my brother, Brian. 13 of those are in New Hampshire. We have 75 stores open and operating right now in 5 states on the East Coast. 37 of those stores are in New Hampshire. So right now the state represents about half of our brand as far as open and operating. And we currently have just myself and my brother upwards of 270 employees in New Hampshire. If you take into account, those are only 13 of the 37. We have well north of 550 employees right now in the state, with 8 additional stores in development in New Hampshire alone over the next 18 to 24 months. I want everyone to understand that our workforce is made up mostly of young high school and college kids. This is their first job that they receive. In some cases, we are teaching them how to mop, how to wash dishes for the first time. It is incredibly burdensome to ask them now to take a food manager level certification. There is no need for these young kids who we work around their school schedules, we work around their school sports schedules, all their extracurricular activity. We are really looking to build solid workforce kids, like entering into the workforce in New Hampshire and their surrounding states. Asking them to learn what the correct temperature is to store or serve shellfish or chicken, or how to refuse damaged cardboard, all of which does not fit our business model whatsoever. I have provided written testimony to the Senate committee that did pass and support this bill, and I'd be happy to share that information with the House and this particular committee to understand the financial burden on this. This course is incredibly difficult to pass the first time. They don't charge as much to try to attempt to pass the second time, but in our experience, only a 40% passing rate happens the first time. And unfortunately, I just found out today that ServSafe increased their cost for this course by 8%. So all my numbers that I've previously submitted to Senator Gaida and his team are already 8% too low. Just for the 13 stores that I operate, this results in about an $80,000 a year cost to me. And once these kids have it, they can carry that on with them and take them to other places or other establishments. And we do not serve food from a raw state. All of it is thaw and serve, or all of it is reheated in store. We're not handling raw products to the consumer. And it's one thing when you're serving $3-4 cups of coffee or energy drinks and a donut, that's much different than serving $24-30 plates of seafood or chicken or steak. So I believe the intent was good. I mirror Senator Gaida's sentiment that HHS has worked with us and changed the verbiage to fit businesses like myself, that we are requiring food handler certifications from our staff, which is plenty. We still have food manager certification people on staff at each store. They are available for all the hours that we're open, but they're not there physically on site. And I think if everyone would read the language in this part 13, they'll understand that this is a great compromise, and it actually serves out the intent of when HHS adopted the 2017 FDA Food Code Standards rule. I think we've done a great job here getting the intent implemented. And again, I want to thank everyone for their time, and I'm here to answer any questions if there are any.
Thank you. Are there any questions?
Yeah.
Representative Satek.
Mr. Sillen, one of my students works at your Salem and dairy store. You're working her too many hours. It's hurting her grade.
I don't think that's relevant, Representative Satek.
It's important.
I'm sorry, sir. Hey, find us some more willing to work great kids, and I'd be more than happy to employ some more of them.
Representative Fellows?
Yes, I would. Thank you, Madam Chair. I would just like to ask the person testifying, if he could repeat what the license that, or certificate they already have is food handlers? Is that?
That's correct, Representative Fellows. What we did, so that everyone understands, we were dealing with this issue pre-COVID. And in those discussions, HHS allowed us to apply for, and we received a variance waiver for this particular rule. So there are some cities that we operate in that self-inspect, and there are other cities and towns and municipalities in the state that rely on state inspectors. Well, we applied for and received a waiver variance. Part of our waiver variance, Representative, is that because we are a growing brand and because we have 75 stores, we do monthly self-inspections of all of our stores. We make sure that they are clean. We make sure that all the equipment's operating properly. We make sure that the temperatures are correct. We make sure of all those things, and we provided all that information to HHS. And in addition to that, we are requiring all of our employees, as part of their onboarding training, to take a ServSafe food handler certificate. It's a $15 course. It's much more geared toward what these kids will be dealing with: temperature safety, hygiene, allergens. It's the meat and potatoes of working in the food service industry. It's not the technical, long, drawn out 6-hour course. It's a 2-hour course that much more aligns with the business model that we run. And that one is very informative, much easier to pass, and much more affordable, and what I feel suits our business model much better.
Follow up?
Follow up?
Thank you. So this certificate that your employees are getting, is that doesn't fall under the state licensure, is that correct? Is that from an independent source, and there's no state requirement for that, or not? Is that not correct?
It is my understanding right now that is not a state requirement. It is one thing that we're doing to go above and beyond the requirement to prove that we understand the intent of adopting this rule, but we have a better way and a more structured, and it fits our business model better. But the food handler certificate, in my experience, is not required at any state level.
Thank you.
Okay, other Representative Schultz?
Madam Chair, my question is actually for you, one of my classic dumb questions. And I do appreciate Mr. Sillen's testimony. My question is it safe to say that this topic is probably very well understood in one of the other committees like Commerce or HHS, especially if these requirements are new?
It's possible, but it's close enough.
Oh, okay. I just feel like the expertise on this topic is probably, I mean, some of us have it personally, but you know, if these requirements are fairly new and the implementation around those requirements were already underway with another committee, I just think it would be helpful to hear from someone from that committee.
I would think that the committee involved would be HHS. They have already committed to contacting them about Section 8, so I will mention this one as well.
Thank you.
And the next, if there are no more questions for Mr. Sillen, I'd like to call Colleen Smith from HHS.
Good afternoon, Chair McGuire and members of the committee. For the record, my name is Colleen Smith, and I'm the administrator of the Food Protection Section within the Department of Health and Human Services Division of Public Health Services. I want to thank the committee for this opportunity to speak in support of Section 13 of Senate Bill 133 regarding the program rules within DHHS for the sanitary production and distribution of food. The department has worked closely with Senator Gaida on this bill as amended to address concerns with the department's food protection regulations, in particular the Certified Food Protection Manager requirement. This became a requirement when we updated our program rules to incorporate the latest version of the U.S. Food and Drug Administration's 2017 Food Code in August of 2019. This bill as amended addresses the concern of hardship to small businesses. While we feel that there is there is importance to having that certified food protection manager on staff, we feel that we have crafted a bill that allows flexibility for certain low-risk businesses when food preparation is limited to reheating commercially prepared food, handling ready-to-eat food only, or when this food establishment has 5 food employees or less on duty, as long as there's already one certified food protection manager on staff. I also want to note the department has also started a rulemaking process to amend our administrative rules to align with the changes proposed in SB 133. And we're hoping that those rules will go before the New Hampshire Joint Legislative Committee on Administrative Rules within the next few months. Thank you again for allowing me to speak to this bill, and I'm happy to take any questions that you may have.
I have a question. How can you revise the rules if you don't have the statutory authority?
So we had believed that we did have within our rules, we had already had some exemptions to the certified food protection manager requirement. So along with this legislation, we had concurrently started to update our rules. We just submitted that fiscal impact statement. We haven't had the public hearing, but we had worked both past knowing this legislation was in progress, and we had worked with Senator Gaida and had spoke with him about doing rulemaking as well.
I see. Representative Schmidt, you have a question?
I do indeed. Thank you, Madam Chair. So, Ms. Smith, I believe, Colleen, I'll call you. So, certified food protection on staff, I believe you said. Aroma Joe's, the example that we were just dealing with, doesn't sound really like a small business if they have 100 or so establishments all over the place, but they're individually small. I understand that. How would this food service protection trained service, I've got the title wrong, but you know what I'm talking about. How is this person going to be able to take care of that responsibility with hundreds of small establishments? They're tiny. We've got several here in Dover.
Yes. So, and Mr. Sillen, if he would like to also chime in with regard to this, they do have a certified food protection manager on staff already. As he had explained, this will help his model. Certainly those later hours, maybe that 5 to 9 shift when that certified food protection manager wouldn't be present on at the store, but certainly available by phone if there was a situation that they were needed.
Follow up.
Follow up.
I understand that they would have such a person on staff, but the question is, this person, how would the protection aspect work with dozens in the state of New Hampshire alone? How would this person be able to oversee conditions in the individual shops?
So having that individual on staff, the expectation is that the restaurant or food establishment has policies and procedures that are protective during all hours of the operation, whether it be allergen control, whether it be sanitation practices, whether it be employee health and hygiene. So having that higher level certified person on staff, the idea is even in hours when there is a lower risk operation happening, that those prerequisite policies and procedures would still be carried forward even in the absence of that person being physically on site.
And this aspect is something, follow up, and this aspect is something that you have thoroughly thought through?
Yes, we believe that that there are certain instances where we can allow some flexibility, and certainly if we through an inspection process find volatile situations time after time again, we can always make that recommendation that they have that certified food protection manager present during longer times. But we're hopeful that with what we have crafted is that we won't be in that situation at all.
Okay, thank you.
Sure.
Representative Goley?
Thank you, Madam Chair. I just want to follow up on the chair's questioning in regards to rulemaking. So is there rulemaking currently is it in the process to address this issue?
Yes, we have started rulemaking that would have mirror the language that's presented in this bill.
Follow up?
Follow up?
Is it normal practice to do rulemaking prior to a bill being adopted?
So we had, in our discussions with Senator Gaida, we had said that we were since we've been working on updating this rule and crafting the language for several months now, and not knowing what was going to be the outcome of this bill. So we wanted to have both options available.
Follow up?
Follow up?
So can this issue be addressed without this being in place? This language into statute?
So that that would be again, we haven't gone through the full rulemaking process, the public hearing process, but certainly I think there is a pathway for both avenues, whether it be in a statute or in rule.
Thank you.
Are there other questions? Representative Fellows.
Thank you, Madam Chair. Just along the same lines that we've been speaking, do you anticipate that the rules will have some kind of guidelines for these situations when the person needs to be an employee but doesn't need to be on site? For example, will it say that they need to inspect once a week or something along that line?
So we have not put in that type of detail in our proposed rule. Right now, the language that we are proposing in rule is very much mirroring what is in the in this bill.
Thank you. Are there other questions? Does anyone else wish to testify on section 13? If so, please raise your hand.
I might just mention, if this ever gets there, enrolled bills should change 5 food employees or less or fewer.
Thank you, Representative Sitek, for that correction. I don't see any hands up. So since no one else seems to want to speak, is there anyone else who wishes to speak on a previous section that didn't get the chance to? Still no hands, so I will close the public hearing. Thank you all for lasting through it, and the subcommittees will start meeting tomorrow.
Question of the chair.
Yes, sir.
So are we, obviously we didn't hear from Senator Reagan in spite of our best efforts. Do we have any outreach to him with regard to any remarks he would have made if he'd been available?
I think his constituent and Ms. Smith probably said as much as Senator Reagan would have.
Right. Well,
Probably more, actually.
well, I know, I appreciate the technical expertise from Mr. Sillen and Ms. Smith entirely. It's just that, you know, we certainly made our best effort to try to contact Senator Reagan.
Yes.
Can I ask this?
Madam Chair, quick
Excuse me,
question.
Ms. Smith, are you still there? We have a question from Representative Sytek.
I'm just wondering, isn't this current practice? I mean, this is the way things are operating right now in New Hampshire, right?
Well,
I guess not. She may have left when we closed the hearing.
Sorry, sorry, Chair McGuire, I am available to answer any additional questions.
Okay, reopening the hearing. So would you explain if this is current practice or not?
There, I didn't mean to reopen the hearing. I just take advantage of the fact that you're here. Isn't this current practice? People aren't, you know, we haven't had, you've mentioned there's really been no issues. Is that correct?
I'm sorry, just looking for some clarification. No issues on the enforcing the requirement?
In the area touched by this bill, are you having problems with restaurants, with food poisoning, with issues? I mean, it seems things seem to be running pretty well, right?
So,
Well, I mean this is a casual conversation after the hearing. It's too bad it's like this, but this is chat. Was what why is this happening? Why is this bill happening?
Because the feds wanted.
The feds want it? All right.
We made the mistake of adopting the 2017 FDA rules.
That's why we have mushroom harvester licenses after all.
All
Yes.
Yes.
Representative Pearson.
Gotta stop listening to that.
Madam Chair, I'm just looking, could you remind all of us on eDNA which parts of this are assigned to which subcommittees, and so we
I
can
just got
make sure we're.
reminded that we didn't meet the 24-hour notice. So tomorrow morning, section 7 will be with the Representative Sytek subcommittee, and section 5 will be with Representative Roy's subcommittee. And the rest will be with Representative Yakubovich's subcommittee next Thursday. Yes.
Right.
Just to be clear, section 2, I thought you moved to somebody else. Is that still staying with my?
I tried to, but it doesn't meet the 24-hour notice for subcommittee work sessions, so it will remain with Representative Yakubovich next week.
Very good, thank you.
Okay. Representative O'Brien, do you have a question?
Thank you, Madam Chair. When did you say part 7 was going to be discussed? Because I do have a doctor's appointment tomorrow.
10 a.m.
10 a.m. Would it be okay to leave early, or do you see a difficulty? And if there is a difficulty, I may ask to be replaced. The appointment is in Boston, unfortunately.
Okay, well, we will, it is just a subcommittee, so we will be glad to have you for as long as you can attend.
I thank the chair. Thank you.
Just do telehealth, Mike.
It sounds like it's not a psychological. Representative Fellows.
Thank you, Madam Chair. I had a question about the anticipated schedule for the subcommittees to wrap up all their work, because I'm on the one that has almost all the bills in it, and we don't have our first meeting until next week.
Yes, well, the main point is that you need to look at, is this section necessary? And if so, is it correct? So if you can finish your work that day, great. If not, we'll have to continue it to some later date.
Okay, thank you.
And Madam Chair, I have a question regarding the bills that we retained, because when do you think you'll be assigning, are you going to assign subcommittees to those retained bills?
They have all been, subcommittees have been assigned, and the notice went out several weeks ago, actually.
Okay,
Once we're through with the Senate bills, I'll issue an updated list, including any Senate bills we may be retaining. And the ruling we have from the speaker is that once we're through with our Senate bills, we can start working on retained bills. And I would strongly recommend that we meet at least once in May or June in order to scope out the work we want to do on the retained bill.
thank you.
Some of them may need research or something else, and we'd like to get that started early. Yes,
And Miriam would have sent that schedule out?
I'll resend it.
Thank you.
Subcommittee chairs have to read the script. We're going to do that same deal.
Yes, you have to read the script. And in fact, I just got a notice from Miriam on how to run a subcommittee that I will send to the subcommittee chairs.
This will be exciting.
It'll be thrilling. We'll all get a chance to learn the script.
Wow.
Send it to all of us.
That's true. I'll send it to everybody. I think she did, actually. Actually, no, she didn't send it to everybody. Any other issues? In that case, have a nice evening, and those of us on the Representative Sytex committee will be here tomorrow morning.
I'll remind Representative Schmidt, he's welcome to participate. I'm not